Okay. Well, welcome to the second day of the quarterly board meeting of the California Board of Psychology. I'll give more of a preamble when we reach the shank of the meeting, but for the moment, we're going to be going into closed session shortly, but before we do so, I would ask that Ms. Burns please take the roll.
Absolutely. Bernal?
Aye.
Kasuga?
Present.
Cervantes?
Here.
Fu?
Present.
Harbsheets?
Here.
Horn?
Here.
Phillips?
Present.
Quorum is established.
Thank you very much. So we are now going to go into closed session pursuant to Government Code Section 11126, subsection 3, subsection C, subsection 3, to discuss disciplinary matters, including proposed decisions, stipulations, petitions for reconsideration, and remands. This is carrying over from yesterday. And we expect to be back no sooner than 10 o'clock. So open session won't start before 10 o'clock. Thank you very much. We're now back in open session. I didn't read the preamble this morning because the audience was pretty empty. Good morning and welcome to the quarterly meeting of the California Board of Psychology, Day 2. I wanted to ask all of us to please turn our cell phones and other devices to silent. You may notice board members accessing their laptops or other devices during the meeting. They're using the devices to access board meeting materials that are in electronic format, in keeping with our efforts to move to a paper-light, environmentally friendly process. We've allocated time on the agenda for public comment, and we'll ask for public comment on each agenda item. I ask that you be respectful of our time constraints and the need to conduct and complete the board's business. If there are several members of the public seeking to comment on a particular agenda item, I will set a time limit on each speaker to ensure maximum participation by all in the context of a busy agenda. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. In making public comment, please do not identify any licensee or registrant of the board by name in order to avoid prejudicing future action that may be required of the board members in our capacity as a deliberative body in enforcement proceedings. We've already called the meeting to order earlier this morning and taken the roll, so we have a quorum present. So I think we can therefore move forward in the agenda. Pull that out here. Okay. Mm-hmm. We're going to do 18 next? Well, we have to do 17. So this is for public items, comment for items not on the agenda, item number 17. The board may not discuss or take any action on any matter raised in the public comment section, except to decide whether to place the matter on the agenda of a future meeting pursuant to Government Code Sections 11125 and 11125.7, subsection A. Is there any public comment for items not on the agenda? Yes.
Catherine Campbell with California Protective Parents Association. I just wanted to let you know that yesterday I noticed that you had reviewed some of the new laws that are forthcoming and have been approved, but what was not on there was AB 1179. And 1179 is something that our organization has worked for 15 years to try to get passed. And it's because when there is an evaluator that is working with a case about child sexual abuse in a family, for 3118, we realized that many of the requirements for 3118 are not being followed. So 1179 is actually a form that is going to be required to be filled out starting in 2021, and the Judicial Council will be in charge of creating that form based on 3118. So I think this board, I know we've had many people come here because of the crisis in the family court system, and child sexual abuse and other abuses are being dismissed by psychologists and your licensees. And so I think you need to be aware that this is a very important step forward for more accountability and a chance for victims to have better, have the law more enforced. Thank you.
Thank you for bringing that to our attention.
Can I just ask a question? What did you say that was based on, the form was based on what?
3118.
Thank you.
Family Code Section 3118.
Okay,
Good morning.
Good morning, Kathleen Russell with the Center for Judicial Excellence. I just wanted to follow up on the April meeting where this board moved to adopt some changes that were recommended by the Enforcement Committee. And I understand that committee, or that board meeting, was the last meeting of the chair of that committee, Ms. Aqua Badu, I believe her name is.
Okwebadu, yes.
Yes, and I didn't see any reference to the Enforcement Committee on the agenda for this meeting, so I guess I just want to be the nag here and follow up and make sure that there's some...
It will be discussed as
It
part
will
of the
be
enforcement report.
Okay, perfect.
Okay?
Thank you.
Sure. Any other public comment on that item? Item number 18, timely enough, is the enforcement report. Ms. Monterrubio.
Good morning. So attached to the enforcement report is the overview of enforcement activity, which conveys the complaints, investigations, and discipline statistics to date for the current fiscal year and the corresponding statistical legend as well. The enforcement unit intake position is currently vacant, and as a result, the enforcement team is sharing in the responsibility by opening complaints, answering phone calls and emails, and distributing mail. The team is doing a great job sharing these additional responsibilities while maintaining their heavy workload. Since July 1st of 2019, the board has received 77 complaints. All complaints are opened and assigned to a desk investigation within 8 days of receipt. Since July, we have issued 4 enforcement citations, and again, enforcement citations are issued for minor violations such as false or misleading advertising and record keeping. Since July 1st, we have referred 7 cases over to the Office of the Attorney General for formal discipline. And we are currently monitoring 62 probationers. However, of the 62 probationers, 23 are in a told status. Told means that a probationer is not practicing in California or may not even be residing in California. So they're in a told, kind of like a hold, suspended type of status. And at our last board meeting in April, there were inquiries regarding the outcome of how discipline in an accusation was determined based on public information in our email blasts, in our newsletter, and posted on our website. And I just kind of wanted to go over the process. So the posted accusation information provides a high-level summary of the facts of the complaint. And prior to discipline being imposed, each case is thoroughly investigated and analyzed. An investigator collects evidence, conducts interviews, and a subject matter expert reviews the entire case file and opines as to whether or not there's a departure from the standard of care. Once the case is sent to the Office of the Attorney General for filing of an accusation, the Deputy Attorney General reviews the entire case file and determines if there's clear and convincing evidence to prosecute the case. And as a result, each case is considered to be fully investigated and analyzed by an assigned analyst, a subject matter, an investigator, and a Deputy Attorney General before an accusation is filed. And that is all I have for the enforcement report. Are there any questions?
I have 2 questions. One was, I don't know if you specifically addressed it. I don't believe you did. What is the status of the adoption of the child custody, the outcome of the child custody stakeholders meeting?
So at our last meeting, what was presented to the board were the recommendations from the committee, and that was to write FAQs explaining the complaint process, additional training requirements for our experts, and the board did adopt that. So now at our next committee meeting, which is going to be next month, we are going to discuss that more thoroughly with the committee and then bring those recommendations back to the board as to what the training will be and to take a look at the FAQs as well.
Okay. So there has not been a committee meeting since the last board meeting because of the change in leadership?
That's correct.
Okay, thank you. Is there any more questions or concerns from the board?
I just had a quick question on the enforcement activity. I just wanted to make sure I'm reading this correctly, because it looks like we've had a decrease in terms of, what was I looking at? Complaints received, correct? So we're
Yes.
down to only 77 complaints, which I think that's significant. Over 18-19, we had 715.
Well, this is since July 1.
Okay.
So we just started the new fiscal year. And actually, in looking at the 18-19, I think we didn't update those numbers as well, so they should be higher. But we typically, if we're at 77 now, I would say that's going to be close to 950 to 1,000 complaints by the end of June.
Oh, I see. Okay.
Yeah, so
Thank you.
77 just from July 1st to right now.
Got it. Thank you.
Any other inquiries or comments from the board? Public comment?
Hi.
Hi, it's Dr. Elizabeth Winkleman with California Psychological Association. I wanted to follow up on the last procedure that Ms. Monterrubio presented. She referred to an item that was brought up at the last meeting by myself and by Dr. Melody Schaefer, who also asked that the item be discussed at this meeting. And basically what it is, I thank you for including that information about how the complaints are processed. And I have some additional information about it as well, but a lot of questions were raised by our members about a particular summary, and I want them to also be educated about it, our members, because what the disciplinary, the accusation and the summary posted on the website and on the in your newsletter said, quote, that the person, quote, engaged in electronic communication, emails and texts with the parents of a minor client during and after termination of therapy, which constitutes gross negligence. Now, this raised a lot of concerns among members because many do email and text with their clients, and there's no, the advice that I have heard and read and laws that I've reviewed do not indicate in any way that that's gross negligence. And I understand that the board cannot discuss a specific case, and we're really not interested in discussing a specific case. I have a couple of questions and clarifications I'm hoping that the board or Ms. Monterrubio can address. So we don't care about this particular case. I understand that that's confidential. But the first question being, does the board have any guidance that it can provide regarding the use of emails and texts and what might be considered the standard of care in their use?
I could respond to it without discussing the specifics of the case. It was in the context of the case that it was inappropriate for electronic communication to be happening, as opposed to there's a general rule that you can't do electronic communication. I don't think we're suggesting that. But more importantly, it's understandable on the part of licensees, but licensees treat these small summaries, which cannot capture all the facts of the case, as if they're precedential decisions that are somehow dictating their further course of action. And although we can't talk about the specifics of the case, it was a very particular situation involving somebody that, well, I'm not going to talk about that. So I think we've only adopted one case as a precedential decision of this board. It's very fact-specific. So it is understandable, but it is sometimes disturbing to see on listservs how licensees react to these squibs as if, and it's kind of almost, there's almost a hysterical quality to it. They need to know that it is a very fact-specific determination made in the context of a broader set of circumstances, and often involves an attorney who's representing the person and also has an opportunity to do that. to defend them, and in this case, I think there was a stipulated decision. I think that was clear from the summary. So I don't know that we can address it much better than that without talking about the specifics of the case. But rest assured, it was within the context of the facts that was of concern.
Okay, that's very helpful. I believe that, I understand, I think that the psychologists look to those partially as an educational tool. They don't want to be, they want to know that they're not doing something that the board, by the plain language of that summary, would say was grossly negligent. So is not one of the purposes of actually publishing these summaries to be educational to consumers and to psychologists about what's expected, what's considered the standard of care?
It's certainly an interesting way for them to learn, but I don't think that those squibs can capture the specifics of the case. So it should be generally educational, and perhaps if we had the opportunity to do it again, we would have stated that summary in a slightly different way so people would know it was very fact-specific. But I think they shouldn't read too much into reading those squibs. The idea was to give more information, but if the more information is going to turn into disinformation, then we have to revisit the whole question of whether we should publish the squibs at all, I suppose.
Mm-hmm. Well, I really appreciate your comments, Dr. Phillips, and I do think that realizing that if people are using those squibs for in part to become aware and to make sure that they're practicing within the expected standards of care and being mindful of that would be very helpful. And if they're not in fact educational, then it's just perhaps unnecessary and just unnecessarily embarrassing if there's no other purpose to providing the details.
Well, maybe
about
we
those
will
cases.
revisit that question in the enforcement committee to see if there's anything we want to do differently about including those or not including those. I don't think we're mandated by law to include them, but I do think it does have an informational purpose for people.
Okay, thanks very much.
Dr. Schaefer?
Hi there, Dr. Schaefer from CPA Division 2 Board and from KPIC. I'm not interested in hearing about the case, but I am concerned about the reactivity that happens in the field. I've seen a lot of psychologists that since then said things of the ilk of, I text my patients all the time, and I don't know that that's necessarily good in and of itself, but I think what was just said about the reactivity is true, and maybe you don't need to publish those squibs, or whatever they're called, squibs. I don't know, I don't know the vernacular. What I think would be helpful, if the board would consider it, is putting out some kind of material, educational material. Maybe it's not within the auspices of what the board is able to do, but something about appropriate and inappropriate use of texting patients and emailing, because I think there is confusion. I attended a ethics and legal course a couple years ago where they brought up that if you even text a patient, you should print the text and put it in the chart, which I think is a good idea, all written communication or electronic in some form. But I don't hear that as kind of what is put out there in general to folks. So I think it's an issue of confusion and lack of specificity of what to do or different messages individuals get. And this could be a wonderful opportunity for the board to see this as a teachable moment, as opposed to one that's kind of defending against the squib, which I think is actually secondary to the bigger issue, where this is a helpful area to educate on. So thank you.
So to address, I'm not sure y'all were here yesterday when we talked about getting social media guidelines for for the board and for y'all, for the licensees, and that's something that the board's going to be doing, so that should address that.
I think that is great, Dr. Horn. I think for a lot of folks out there, I've run across people that don't see social media, unfortunately, as the same thing as emailing and texting. To me, it's all the same, and I don't Facebook or any of that stuff, and I have no intention of it, but I think it opens up, when you do our work, to a myriad of other issues. But so many people do, and they parse it out, that maybe this is an opportunity to bring it into the fold and and do some higher education on it. Thank you.
It's an interesting question, Dr. Schaefer.
Yes.
And the reason I say it's an interesting question is because it's our job to enforce, among other things, the standard of care within the profession. The standard of care evolves within the profession. We don't want, as a board, to dictate the standard of care because we'll freeze it in time, as opposed to allowing it to evolve in the way that it does. So there's kind of a delicate balance between trying to be educational and to make appropriate regulations in an area, and in other ways to not interfere with the evolution of the profession. You can see what that...
Absolutely. I guess I'm thinking of, as opposed to standard of care and scope of practice issues, I'm thinking more along the lines of HIPAA compliance. And to me, if you're going to be texting a patient, do we need to be thinking about, is this a HIPAA compliant means of communication? Do you have a release that says that the patient has agreed that you can text them or email them? If you have email at your practice, we have a HIPAA compliant email, but I don't know that a lot of people think that way, and they see as more innocent and just trying to contact the patient like they would vis-a-vis telephonically. But we know that telephonically is very different than media such as that where other folks may be able to see it. Even telephonically, patients, at least for me, they have to agree and mark off boxes. It's okay to leave them a voicemail message at the number that they give. I don't know that everyone else even does that. So as opposed to orchestrating or stipulating, if you will, what must be done, and I appreciate that, you're looking for what the standard of care, maybe just guidelines to help people think about it and contemplate, is that a good way to go? Is that reasonable? Are we protecting the confidentiality of the consumer? Are we thinking about ways that we could do it a little bit better? And who else but the board? I mean, as a guiding...
Well, actually...
maybe you don't think the board, maybe you think CPA, and
Well,
I'm barking up the wrong tree.
APA tends to create a lot of guidelines on a lot of these subject matters. Whether they're actually reflective of the standard of care is determinable in the particular instance, but typically some of that material does come from professional associations as opposed to licensing boards.
Yep, we see...
So we are going to do that, though. I mean, I'm not sure you were here yesterday, but...
Yeah, I was here the entire day.
So that's what
Yes.
we're going to do, and those guidelines that we're going to take a look at and comment on will include texting, will include
Yes.
emails, will include all those forms of social media, also Facebook, blah, 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 blah.
I think that's wonderful, and I agree that APA provides a lot of this information, which is wonderful. But we already see with PsychPack that California is not adopting PsychPack. And if you're on LACPA or CPA listservs and you see, I mean, sometimes I read what people are doing, I'm thinking yikes, and other times it sounds good. And maybe it's just yikes to me and it's not yikes to anyone else, where individuals are interpreting what is not specific and clear as to what they're doing with patients across various boundaries. Anyway,
Thank you,
enough
Dr.
said.
Schaefer.
Thank you.
Any more public comment on the enforcement report? Okay. Moving on from the enforcement report. Oh, I'm sorry.
Good morning, Kathleen Russell, Center for Judicial Excellence. Just wanted to talk briefly about the Enforcement Committee. And while we were very pleased to hear the adoption of some changes coming out of the stakeholder meeting at your meeting in April, I do want to raise concerns that they have not appeared in writing anywhere since, and certainly weren't a part of Ms. Monterrubio's report. There is no mention of the Enforcement Committee even existing in the agenda. So I know that, it doesn't appear on this meeting agenda anywhere. So I have done some research. I've talked about this in the past, that there are other DCA boards and commissions that have public enforcement committees that actually videotape their meetings. And these are DCA boards and commissions. So in the interest of transparency, I guess I would urge again that there be a commitment to transparency around the Enforcement Committee. It would be nice for the public to know who is the new chair, since the outgoing chair did all this work and is no longer with us. I know they're meeting next month, but again, that's not even mentioned anywhere on the agenda for anyone who's wanting to look that up. And I also know that Ms. Monterrubio mentioned 2 of your recommendations, but 2 were not mentioned just now. So I want to bring those up because I want to ensure that those are part of the agenda for the Enforcement Committee. There was, this board adopted that there would be effort to work with the Office of the Attorney General on statutory language that dealt with the subpoenaing of mental health records. I think that's important. And the screening for parental alienation for your screeners who are screening complaints. We've actually learned the identity of one of your screeners in recent weeks, and in our research, we've uncovered some actual cases and court transcripts where this screener is promoting parental alienation. So that very much raises another question for us, is how do we even know or monitor what the board is doing? I know that the screeners are confidential to the public, but you're announcing that you're screening people for parental alienation. How is that going to roll out? What is the timeline? Those will be important questions to ensure the public trust in these changes that you're doing. So I would ask, too, that the Enforcement Committee have an actual implementation timeline so that we have some sense of when these changes will take place. And, in terms of the legislative calendar, we've begun meeting with legislators already for the January session, and this would be the time to be having those discussions around any statutory language that the board and the Office of Attorney General between now and November is generally a good time. So, yeah, I guess I just would say that I'm unclear on the board's commitment to these changes given sort of the short treatment and that only half of them are even just mentioned, and hope that the board was serious in adopting those changes at the last meeting. Thank you.
Actually, if you refer to the meeting materials include the names of all the chairs and members of committees. The membership of the committees changed substantially since Ms. Akwebudu is gone. I'm going to be temporarily chair of that committee, and Ms. Cervantes will be serving alongside me. And you're right, we haven't given you a timeline. We haven't done implementation. That's the next type of step we're talking about at the next Enforcement Committee meeting. I do want to just briefly comment on the fact that we've given you the reasons before, which may not make sense to you, why the Enforcement Committee meets the way that it meets in closed session, so that we can have enforcement analysts there that can talk to us about specific cases and protect their identities. Because from time to time, we do have threats against our enforcement staff. So that may change with some of the legislation that's currently pending before the legislature, but for the time being, everything that we do that involves policy is always brought back here to the board meetings for discussion by the entire board. So we do expect that as a result of the next Enforcement Committee meeting, we will be bringing implementation steps back. Whether we'll have a timeline at that point, I can't promise, but you will have more concrete information at that time. And we do, as to the items that we said we were going to address, those will all be addressed. I don't know if it was 3 or 4. 4?
It's a total of 4, and I didn't go into full detail because it's not on the agenda. But yes, all of the items that you listed that are also in the April materials will be addressed at the committee level.
So hopefully you'll feel a little bit more comfortable that we're still moving forward next time we see each other.
Great, thank you very much.
Thank you.
Hi, Catherine Campbell with California Protected Parents Association again. We appreciate the work that's being done and the stakeholders meeting to address the concerns that we see with enforcement. And one of the concerns, whoops, where did number 18 go? There it goes. One of the concerns is that when we look at our present day situation of what's acceptable and the culture to dismiss abuse. We can all agree that 10 years ago, some people thought it was okay to slap Jeffrey Epstein's hand and let him go on one state's registry for a sex abuser. And And we can see clearly 10 years later that wasn't appropriate. What we're doing now is when we put people on probation, I mean, some of these that I've read, that as long as they give all the documentation to someone, they can still practice. How do we know that that documentation is being sent? How do we know that these people are not harming other people? We brought it to the attention of this board before that when we see something severe of someone, we don't understand why those people are not suspended in a place where they cannot serve at all, that they cannot harm another child. They cannot put another child in the bedroom next to their sexual abuser. We don't understand that. And I think it's very important that we look at these numbers, and they're so low compared to what is being done. I know I'm not sure if you're aware, but we spent some time asking for a audit of the Commission on Judicial Performance. The commission sued the auditor because they didn't want their complaints to be seen. But it came out that they needed to share those. Those weren't confidential. They could share them with the auditor. And the report came back, and it was pretty scathing to know what we are allowing our judges to do. And I really feel as if we're not, we can respect professionals, but when we want to just give a slap on the wrist to someone, we cannot expect them to do what's right. And we're creating a culture that allows people to misuse their license. And I would hope this board shifts a culture to say, no, that is unacceptable, and we will not permit that. We know that there have been very valid complaints that have been turned in and held with you for 3 years and then immediately dismissed. There's complaints with you now that have plenty of documentation, and 8 months, no word, other than we have it. We don't understand why these psychologists are able to continue to practice, or why we would want them to. Because as a society, we have to care more for our children. And we have to understand, the ACE study's been out 20 years, and I think you can all understand. We now have a Surgeon General for California for this very fact that this is a crisis. The ACE study shows that these effects of adverse childhood experiences are damaging our children and our future of California. And it can be stopped here. And if we continue to allow our licensees to not be accountable, when they take money and dismiss abuse, that is trafficking a child. And we need to stop that.
Thank you very much.
Is there any reply?
Well, we've attempted to explain before that as it relates to somebody's license to practice psychology, that is a property right. And we can't just take a property right away based on a complaint unless there are some other things that happen. And there are some mechanisms by which we can suspend people's licenses when there are substantial criminal complaints against them about having committed child abuse or so on and so forth. But we do have to go through the due process of looking at all the evidence that's involved. And sometimes I get the impression there's a gap between what you may consider to be sufficient evidence to prove that someone should no longer be practicing or should be subject to discipline, and the consideration of all the evidence that we receive. I don't know if that's an appropriate summary, Ms. Monterrubio.
I will just state, I have heard you speak. I think we were down in Southern California, and you said even if someone's convicted of not being a mandate reporter, that it's up to this board to decide if they can continue to practice. So even if there's a conviction, and you can go back and look at that because I clearly remember you saying that, but if there is a conviction, it still doesn't matter. I mean, that's where we're at.
I don't know that there's been, that I can think of in the time that I've been with the board, a case where someone's been convicted of not being a mandated reporter and received a criminal or civil sentence for it, and discipline hasn't been meted out. But I'm not privy, because we are the determiners of fact, where we sit effectively as a jury on some of the enforcement cases. It may be that that is the case, but I'd be very surprised.
Well, I'm not sure why you would state that. You're stating now if there's a civil situation that you would be able to work with this, but earlier, you have stated that even if the government decides that they have been found guilty in a court of law, that this board could decide otherwise. That is my point.
I don't recall ever saying that.
Well, I'll send you the video. I have you on video saying that.
Great, I'd appreciate it.
Dr. Phillips, I just want to remind the board to not get too far afield from the item that is agendized, which is the enforcement report. You can decide whether or not there's a more specific item that you'd like to agendize for a future agenda.
Thank you for that reminder. Thank you.
Did you ask Ms. Monterrubio?
I don't know if she had anything to add to what we said.
I don't, I'm not aware either of there being a conviction for mandated reporting that we've taken discipline on, so.
Thank you.
Thank you. So seeing no further public comment, thank you very much for the enforcement report, Ms. Monterrubio. We very much appreciate your efforts on behalf of the board.
Sure.
And item number, we're going to 20? Item number 20 is the health professions. Oh, 19, did I skip? That's why I asked, because I'm a skipper. Okay. The next item is item number 19, discussion and consideration of the board's policy for holding cases for closed session.
So this is just being brought up back to the board because over a year ago, when we just had 6 members, the board decided to just do one vote to hold a case for discussion. And what a hold vote means is that you disagree with one or more portions of the proposed action and do not want it adopted as is. Or 2, you have a question or concern about the decision and would like to discuss the matter with your fellow board members. So now that we have 8 board members, I thought it might be a good idea to discuss if you would like to keep the whole policy at 1 vote to hold or 2.
I'd like to keep it at 1. And the reason I would is because sometimes we have new board members, and it's helpful if they have questions about the process or anything like that, for us to be able to have that 1 vote do that. And sometimes different people see different things and can, if there's 1 vote to hold, that gives them the opportunity to say, hey, what about this and all like that. So for me, I'd like to keep it at 1. And if I'm recalling that, it wasn't because, for my vote at that time, I don't think it was because there were 6 members. It was for the same reasons I'm now stating. I just think that we ought to be able to bring things for discussion. That's my thing.
Which I think is a great point in terms of what can sometimes come out of the discussions that come from 1 vote for hold. There are some times, without getting into specifics, where I feel like we've held decisions for discussion. There's been an enormous amount of material to review, and effectively there's been a question or something as opposed to a real concern with how the decision occurred. So I would guess either I would hope that we go to 2 votes, or alternatively, that people make more use of enforcement staff if they have a question about a particular decision. And I think we've been pretty good about it more recently, but in the past, sometimes people have just had a question they wanted to ask, and it's like, oh God, I just read 115 pages because you had a question. So I would hope that if we stay at 1 vote, that people are very careful in exercising that vote for a hold.
And on the mail ballots, it does state if you have technical questions to please call the analyst assigned, and then legal questions, please contact Noreen Mark. So staff is definitely available to answer any questions, and they're very familiar with the cases. So please do call us if you have any questions that we can answer for you.
I like the idea of the one vote, just one vote, because I feel that when we've had these discussions, hearing the thought process of people has really helped me to understand better what, I have called people, but just to understand what people are thinking. So I feel like it's been an educational process for me also, especially as a newer board member.
And just from an enforcement staff perspective, I'm fine either way, whatever works best for the board. It was just when we discussed this, when we changed it from 2 votes to 1, we said we would readdress it. So that's why it's here today to discuss. But whatever works best for the board, I'm fine with enforcement.
I may be misreading the situation, but it appears that, at least that's the people that have vocalized, that they prefer the one-vote rule. Is that the general sentiment of the board? Okay, that being the case, thank you very much for bringing this issue forward, and I guess we'll stay with the policy that exists.
Okay.
Thank
I just
you.
wanted to add that with a one vote, like one of my thoughts on why I want to keep it to the one vote is that, like, as a licensed board member, I think that, like, I see things from a different perspective, and if there are concerns from the public board members, that should be enough to put that case to on hold for discussion.
And I guess
So I
the
appreciate
point I
that.
was making, and I don't disagree with what you're saying, is that there's a balance there, because every time we put a case on hold and asked for the materials, we've also created work for the enforcement staff to get all those materials together. Not that that should be the controlling consideration, but I just want us to be very thoughtful in the way that we use the hold.
Yeah, definitely. And I think it's a good reminder, too, that we have the enforcement staff ready to help us with questions, and I've utilized that as well several times in the past. But I think that the one hold really encourages, it discourages groupthink and encourages people to have more discussion when it warrants a discussion.
Just one kind of additional, we've talked about different components of this, but one item that we brought for the board the last time we talked about the hold policy is, and this is the biggest concern, I think, from enforcement staff's perspective, is to always be mindful that when you hold something, that individual has a free and clear license, and that discipline is on hold until you guys discuss it. So always just being mindful of that when you do hold. So that's kind of most important in our eyes.
So,
I have a quick
I have a question.
Oh, go ahead.
Oh,
Yeah.
Go ahead.
Say, Ron.
Sorry, just Ms. Sawyer, can you, so let's say, for example, tomorrow, hypothetical situation, let's say tomorrow we get a case and one of us decides to hold, and that means that person will have a free and clear license until our next meeting in October.
That's
or
correct. And usually there's a quarterly meeting, so yes, that person would have an unrestricted license until the board met in closed session to discuss the case further.
And so there's a possibility that if there was a technical question in place that wasn't asked of enforcement staff, but then was held and could have been answered in that sense, we would have allowed a licensee to go on for about 2.5, 3+ months.
That's
Free
correct.
and clear without.
Yes.
I just want to refine that a little bit. That's only true if it's been based on an accusation as opposed to a statement of issues, because statement of issues, the person has not yet been issued a license. And I would also add that I would hope that if, as you hypothesize, if a decision came in yesterday, which would be, tomorrow, which is like would be the longest period of time, if there's going to be a problem, what we refer to as a 100-day problem, that we would set up a teleconference meeting to address that. Otherwise, the board would lose jurisdiction.
So I have a question. This is specific. I recently made a vote but said I wanted to discuss this at the meeting. What I wanted to discuss was an issue, a larger issue. Is that possible without holding? I voted, but I saw a bigger issue in the case that I wanted to talk about. Does that hold the case?
Well,
You know what I mean?
I
Yeah.
do. We received it was a vote to adopt, but you would like to discuss at the next board meeting, which I'm not sure. I'd have to let Noreen answer that as to whether or not we could discuss your concern at a board meeting.
I think the way we handled that in particular, because there was a vote, if there's a vote, there's a vote. And we're not going to say there's not a vote if there wasn't. And I believe there was potentially some lack of clarity, but I think it was either processes or a vote, or we were very close to a board meeting, so it was held. But I said, once there's a vote, there's a vote. The issues with respect to a particular case, we can discuss those with respect to a particular case. If it's a broader issue with respect to some enforcement policies, then we would, if we discuss those, if it comes out in closed session, that's really more of a broader issue, then it would be moved to an enforcement committee.
So just to make sure, my vote was recorded, but we'll be able to discuss this still. So the vote has gone in. It was a vote to adopt.
Correct.
And then if it turns out that in closed session, if we talk about it and it's like, no, this is a bigger issue and this needs to go to enforcement, then it'll just go to enforcement.
That's my recollection of
Okay.
how we had decided to handle that.
Perfect.
That the vote is recorded, because
And
we
I know-
can't not record a vote.
Yeah.
Okay.
Ms.
good.
Bernal?
No, I wanted it to be recorded.
Ms. Marks answered.
Okay. I would say, as chairman of the enforcement committee, if you see a particular issue that doesn't require you to hold your vote on a case, please bring it either to enforcement committees, or the enforcement staff's attention, or bring it to my attention so that it can be agendized for the next enforcement
Okay.
committee meeting.
Okay, great, thanks.
Can I follow up? Question. Not expecting hard numbers, so I asked this question with that preface. So the two set criteria, either because there's a belief that the decision, that there needs to change, the proposed action requires some change instead of an as-is adoption, versus you have a question or concern about the decision and would like to discuss with your board members. Is it what's the split on that? Is it usually the former or the latter, anecdotally speaking?
I would think that most often it's that the board just has a question and wants to talk about it in closed session versus not necessarily unhappy with the proposed action that's listed.
Okay.
So it is fair to say, Ms. Monterrubio, that enforcement staff sometimes feels, let's say frustrated, I don't want to say stymied, but sometimes frustrated by the holds in particular cases because of stopping either the enforcement process or the licensure process?
I would, again, don't want to say frustrated, but yes, I would agree, because we receive calls from opposing counsel and from the AG's office kind of asking for status updates. So I think everybody wants to get the process moving if we can. I think another challenge that enforcement faces, which I know that you don't have to do, but there is a section on the mail ballot for you to put down your reason to hold a case, and I know that you don't have to, but sometimes if that was noted, if you were comfortable doing that, and it is a question that enforcement staff could answer, we would pick up the phone and call you immediately and get that question addressed. So again, if you'd like to put that, and there's another reason to maybe note that as well, so that when I give the mail ballot results to Dr. Phillips right before closed session, he knows who held and why. I don't share that with any other board members. I give that directly to the president. But again, please feel free to call. I know with your last vote, Dr. Horn, you did say adopt, and I'd like to discuss, but we didn't know what you wanted to discuss, so, right.
And I do have a quick question though for Ms. Marks. So the only time that you all could schedule a conference call if it's within that 100 days?
It depends on where the matter is, and if it's a stipulation, if it's a proposed decision. You have 100 days from the time the proposed decision is issued to act on the proposed decision. And generally, I don't know that it's happened too often where we get a proposed decision, like right now, where we'd have the longest period of time until the next closed session. It's probably happened, and then we would schedule a teleconference meeting. If it's a stipulation, we don't have that same constraint. So it depends on what the matter is.
Yeah, usually with the proposed decisions, we have enough time to discuss them at the next board meeting. I think we've run up against the clock maybe once or twice in the last several years.
Right. And I think generally I've discussed with Ms. Monterrubio that if the board receives a proposed decision shortly before a meeting, that we're probably better off bringing it to closed session rather than doing a mail ballot, because you'll get, the staff will get the decision that much sooner, and we won't run into that problem where it's done by mail ballot. You end up voting the day after a board meeting. So we've discussed that as well to try to cut down on any issues with timeliness.
Thank you.
Sure, go ahead.
So the statement of why we're holding, it's optional at this point. Could you share if we know why it's optional, or given the fact that it's held in confidence with you and the board president, is there a particular reason why it's an optional thing to disclose why you're holding, or?
From what I can remember, I think there was a discussion some time ago that the reason for it being held really was an issue that needed to be discussed with the board members and not with the staff. If board members had questions for staff, they would direct those to staff. But for us, again, it's helpful if we can help you get your question answered. But again, I know that you're not required to. Whatever you're most comfortable with.
So my concern is that because a license is in free and clear before we have that discussion, and if we're holding something but we're not sharing with staff in a confidential manner to identify and potentially resolve that in a way to shorten that timeline between that hold versus a board meeting when we go into closed session, that's where my concern is. If we're not optionally disclosing that, we may be holding something that could have been resolved privately, quickly, and also in the pursuit of protecting consumers in a shorter time frame. And so I'm not suggesting that we go into a mandatory, nor am I suggesting that holding isn't,
Sure.
because I value the discussions that we have, and it's fantastic to hear the different viewpoints. For me, it's the concern if it's a technical issue that isn't being shared,
Right.
then we are potentially waiting longer than we need to. And that's just my interest in wondering why we aren't disclosing.
I think I'm the one that's been probably the biggest fly in the ointment as it relates to that. I have a personal reservation about specifying reasons that are going to be discussed in closed session with enforcement staff when they are the prosecutors and we are the judges. So I don't feel comfortable doing that. But I also don't think that I can recall, maybe people can correct me, Dr. Horn and I are probably the longest serving at this point. I don't think I've ever held anything for a technical reason without asking board staff first for clarification as to the technical reason. It's typically, for me, it's a substantive reason that I'm holding.
And I've spoken to several of you before, and I know that you've also spoken to enforcement staff. So, again, I just want to reiterate that we are here to answer any questions, and so is Noreen for legal questions.
Dr. Phillips, I want to address that potentially the board can consider a way to get around that. I am very sensitive to what you're suggesting, which is the reasons why you might be holding would be something discussed in closed session outside of purview of the staff. I've also experienced that sometimes somebody forgets why they hold. So we hold it, but somebody has a very good reason but can't remember why because it hasn't been noted. So possibly there's a way of either emailing legal, both to see if there's a question that can get answered outside of the hold, and a repository for those concerns so that when we're in closed session, it's not like, who held this and why? And
people will go, I don't know, nobody looks around.
What would be helpful in that regard is, like, if you put the name of who held it, because, like, I found out, you said you were one of the holds, and I was like, oh, yeah, and then, boom, I knew why.
And that's what I think
Yeah.
Ms. Monterrubio and I have been making more of an effort to do, for her to tell me who put the case on hold so that we would know, or if there was a particular reason given. So we'll continue to do that so we don't have the unproductive discussions. But I would suggest to somebody such as myself, if I were going to put something on hold, I can also send an email to myself, flag it with the case name within my Outlook box, and then I'll have it to refer back to. That's certainly one way to remind yourself.
A quick question to Dr. Horn. Did you mean like when that on the actual mail ballot results that under it says hold for discussion to also then identify the board member who did that? I would be curious to explore if folks feel comfortable that being listed on the ballot results so that we understand, so that there is that reminder when you're asking the question in closed session who held it, we already have it in the mail ballot results. And just for us to better understand who's holding and in preparation for that.
Doesn't go back to what your concern is.
It's a name versus a reason. I think if it's a board member holding the name.
I do personally feel like board members should be able to put it on hold without it becoming public to all the other board members until such time as we have the discussion. But I do think it's important that we keep track, and as you have been doing, Ms. Monterrubio, identify for me who's putting it on hold so that I will know who to ask why they put it on hold. And that helps to start our discussion.
I am thinking, however, that for clarity purposes, when the board staff reviews the mail ballots, that if you have a question before you hold, to try to get that, to see if there's a question can be answered. Otherwise, the board staff is going to say, well, but we have a hold. What do we do with it? Do we send you out a fresh ballot to see whether or not your question has been answered? So the board staff isn't wondering how to count the votes.
Agreed. Is there any public comment on this agenda item? I think yes, Dr. Linda Crow. Actually, before we take your public comment, Dr. Linda Crow, I've had some urgent requests to use the restroom. So I think we'll take a break and come back to the public comment. So why don't we take a Okay, we're going back into open session, and we were waiting for commentary from the ever-patient Dr. Linda Crow.
Hi, Dr. Joe Linda Crow with CPA. I just had a couple of questions and clarifications because it's been a fascinating conversation that I think often licensees don't quite get the whole process of how this whole thing works. I wanted to ask you, Dr. Phillips, about one thing you said, just to clarify. You referred to the staff as the prosecutors. Could you explain what that means?
Ms. Marks might do a better job of this, but basically, at the point where we're sitting as a board to discuss and vote on an enforcement case, we're similar to the trier of fact or the judge or the jury, whatever. And the complaints being brought by the executive officer, and in those proceedings are represented by enforcement staff and typically a DAG or whatever. So we have to maintain a distinction in that role, which is why, for instance, we don't discuss the licensees' names because this board may have an enforcement case that comes to us, so we don't want to have specific information about a licensee before we actually just have the evidence before us. So we have to be careful about keeping those roles clear.
That's when you're going to vote on an enforcement case. And I just also wanted to just clarify, because sometimes we get this question, this board can overturn a decision of the administrative law judge. Is that right?
We received the proposed decision. I'm sorry, Ms. Marks, maybe I'm preempting you. We received the proposed decision from the administrative law judge, and we review it based on the materials before us, and then we make it. That's where the votes occur. Okay. Are we going to adopt, or do we want to hold this decision so that we can have a discussion?
So that's what you were talking about. So you can vote to adopt the recommended decision, or
we can modify the decision.
You can modify it, or you can reject it.
We can send it back to the judge to take additional evidence.
Okay.
We can do a variety of things under those circumstances.
Okay, and does the board look at every single decision that comes forward? Is every decision seen by this board?
I think the only exception would be stipulated surrenders because that authority to adopt those are delegated to the executive officer in regulation.
So that's typically where there's already been an agreement, and either the person's stipulating at the outset that they're going to surrender their license,
Right.
or they've entered into a stipulation where they go on probation. It gives them the option to surrender their license at some future point in time if they don't want to continue to be under probation.
But
So
other than that, the board, all board members see all the cases and.
we sure do.
And see the recommendation. Yeah, I'm sure
Yeah.
that you do.
We
Okay.
actually, and it's interesting for the public to know, we actually spend a fair amount of time between board meetings reviewing documents and voting on whether to hold proposed decisions or voting to adopt proposed decisions.
I do think it's important for licensees to know that the board members themselves see these decisions, the recommended decisions, and take action on them. That is not done at the staff level. Is that right?
No, and that's
Except for the exception that you pointed out.
That's the beauty of having a board that's comprised of licensees and
Correct.
public members,
Yes.
so that there can be an active discussion about everything that relates to the protection of the consumer, but also that the board members that are licensees can also bring to bear their expertise in the field
About the standard
to
of care.
provide
and
to
stuff.
provide a
Yeah.
context
Great.
relative to standard of care.
Okay, that's helpful.
And if I could just add, so enforcement staff will email this information out to the board, and the board is given 10 days to review a case.
Oh, okay, good. Thank you.
Oh,
That's
I was
helpful.
just going to
Thanks
add
for
one
that.
thing. We talked about ALJ decisions, but also stipulated decisions that the person has agreed to, the psychologist has agreed to, and we might change that based on our review.
So you do see those, or just the executive officer?
With stipulated decisions, we do see the stipulation, and we can, which has been what's been negotiated with the assistance of the Deputy Attorney General. It's been negotiated between enforcement staff and the executive officer and the licensee and perhaps their attorney. Those still come to us, and they're subject to approval, so we still vote on those.
And I believe you've seen not only the stipulated decision, but the charging document, either the accusation
Correct.
or the
I mean, there's a
statement of
variety of
issues.
documents that we can receive under
Okay.
particular circumstances.
So I thought you said earlier that with stipulated decisions, the board did
No,
not. see-
only stipulated surrenders.
Okay, good.
Yes,
Thanks for that.
stipulated
Okay,
surrenders. Yeah,
Thank you.
Because there's
Got it. Thanks for that clarification.
Elizabeth Winkleman again, California Psychological Association. And I just wanted to ask about also, because this is really interesting and I think it's helpful for people to understand the board's role in the decision-making. What about things that are a lesser level of discipline, such as a letter of reproval or citation and fine? Are those things at the staff level or?
Well, with a PLR, a public letter of approval, there's always an accusation filed first, which is signed by the executive officer. PLRs are discipline, and as stated earlier, all discipline cases except for surrenders go to the board.
So public letter of approval, and what about the citation and fine? Is that?
Those are not discipline, those are enforcement actions. So that is done at the staff level. However, if there is an appeal for an administrative hearing, that becomes then a proposed decision that would then go to the board for consideration.
Okay, great, thanks.
Hearing no further public comment and no further board discussion, thank you very much, Ms. Monterrubio. We really appreciate your help.
You're welcome.
Okay, now item number 20. I'm not even skipping. Okay, so this is going to be a presentation by the Health Professions Education Foundation on licensed mental health service provider education program and the mental health loan assumption program. We have Ms. Norlin Asprecht. I hope I'm pronouncing that correctly. I'm not. Who is the executive director of the Health Professions Education Foundation.
Good morning, board members. I'm happy to be here and share information with you all on our licensed mental health services provider education program. I didn't include some details on the mental health loan assumption program. I'll share that with Antoinette in another correspondence so she can share it with you all. But let me get into the program. But just giving you a brief overview on our organization. Yes.
Really quick, if you could just let the board members know, we have a new board member, what that other program is and
Yes.
the eligibility for both programs. And I know you're going to get into the HPF fund.
Yes. So the Health Professions Education Foundation, we are a 501c3 nonprofit that's housed within Health and Human Services Agency Department, the Office of Statewide Health Planning and Development. With our mission is to improve access to care in underserved areas of the state by providing financial incentive awards in the form of scholarship and loan repayment to those that are working in underserved areas and that they are working within their profession as a healthcare provider or a mental health provider. So the licensed mental health services provider education program. The purpose of this program is to increase the number of licensed mental health providers in underserved areas of the state. This program awards up to $15,000 in the form of loan repayment to pay down their educational debt. Applicants can receive the award multiple times, and they can receive up to 3 times an award. The eligibility criteria includes a commitment to providing direct client care for up to 2 years. The direct client care hours is 32 hours or more each week. They must have educational debt and be free of any other service obligation. So we have awardees that would like to apply again, but they would need to fulfill that 2-year service obligation before being eligible for another award. And then there are other programs within the Office of Statewide Health Planning and Development in loan repayment, so they would need to complete those obligations before they would be eligible for our program.
Interrupt you for 1 second.
Yes.
When you say underserved communities, you're not just referring to historically underserved populations, but you're also referring to places like rural areas and
Correct.
those types of things.
Correct.
So it covers a lot of different parameters in terms of, or several different populations
Yes.
in terms of who's being served.
Exactly.
Yeah.
Exactly. Looking at the provider to patient ratios throughout the state. Some of the eligible professions include licensed and registered psychologists, those that are postdoctoral psychological assistants, postdoctoral psychological trainees, registered or licensed marriage family therapists, as well as registered licensed clinical social workers, and one of our newer professions, licensed professional clinical counselors and an associate licensed professional clinical counselors. On the next page outlines the eligibility sites where providers would be providing care. These eligibility sites do include publicly funded or public mental health facilities, so your facilities that are county facilities, those that are funded by the federal government. In addition to those, nonprofit mental health facilities that are contracted with county mental health entities, and or those designated sites that are qualified and designated as mental health professional shortage areas in the state, and that's designated by the federal government. The licensed mental health program is funded by the Mental Health Practitioner Education Fund. As of July 2018, $20 of every renewal fee that is collected by professionals under the Board of Psychology and those of the Board of Behavioral Science is transferred to the Health Professions Education Foundation to fund the licensed mental health program. In fiscal year 2017-18, HPEF awarded 60 awards that totaled up to $747,832. In that fiscal year, the Board of Psychology's allocation for LMH awards was $75,815. And of those 60 awards, 7 awards were made to psychologists that were supported by the Board of Psychology's allocation. And 4 other awards were supported by the Kaiser Permanente Community Benefit Grant.
So in total, there were 11 psychologists that received awards under the program.
Mm-hmm. In fiscal year 17-18, we break down the professions and the awards, and you can see here the breakdown not only of those that are regulated by your board, but the Board of Behavioral Sciences, and it totals up to 60 awardees.
Can I ask a question before you go on? We had 11, you had 11 psychologists who received awards. Out of how many people might apply who are psychologists?
I don't have that figure off the top of my head, but I believe the number of applications, I don't have the breakdown of the boards and profession, but of the applications we received last year, we received over 700, and then of those, 500 of them were eligible but not funded. And that was just solely looking at our licensure renewal fee funding amount, as well as the grant from, actually, that was just looking at the licensure renewal fees, sorry.
So of that 700, 60 awards were given.
Based off of the funding allocation, but there are more eligible but not funded. And that amounted to about 500.
Okay.
For this past fiscal year 2018-19, we awarded 27 awardees, and that amounted to $270,000. Of that fund, the Board of Psychology allocated $90,000 for licensed mental health awards, and of those 27 awards, 6 awards were made to psychologists and was supported by the board's allocation.
So just so everybody can be clear,
Yes.
we've now moved on to a different fund, correct?
No, this is the same fund.
Oh, it's the
just a
same fund.
different. This is our most recent fiscal year.
Oh, okay, so this is 2018, not
Yes.
2000, okay. Thank you.
Could I please ask a question?
Yes.
So who else contributes? You mentioned the Kaiser Permanente Benefit Foundation. Are there other agencies that contribute to your nonprofit?
The only other, into this fund for the licensed mental health program, the only other contributions made is from the licensure renewal fees from the Board of Behavioral Sciences.
Okay, so when there were 200 awards, where were the other 140, or who received the other 140? If there were 60 made, okay, so this is how I heard the numbers: 700 applicants, 500 not funded, and
then you also account for those that 500 were eligible, and we count those that were.
Okay, but then there were okay, I was under the impression then that there were, out of those, 200. Did I misunderstand?
No, there's the 500 that are eligible but not funded, and then we also account for those that were ineligible, and then based off of the fund, we were only able to make 60 awards.
Okay, thank you.
Just that 140 were not eligible? They didn't meet the criteria for the grant, for the award.
And then on the next page, I hadn't made a typo, but on the next page for fiscal year 2018-2019, there were the 27 licensed mental health awards that were amounted to the $270,000, and there's a breakdown of the professions and those that were awarded by each profession.
Real quick question. I think I may be getting where Dr. Phillips had asked the question, because the heading on this says Mental Health Practitioner Education Fund, but then it's referencing the licensed medical, the LMH awards, and so could just quick distinction between one's a subset of the other or whatnot, because that's potentially where we thought we had switched to a different fund.
Oh, okay.
Yeah.
So the licensed mental health program, the title of the fund that is used to support the program is the Mental Health Practitioner Education Fund. Yes. Okay. Okay. Let's see. And then
Okay, I'm going to hit you with another question.
Yes.
So there were 60 awards in 2017 to 18.
Yes.
And there's 27 awards in 2018 to 19.
Yes.
And that includes, that's the total year.
Yes.
So
Yes.
what is the difference between those 2 years that there's half as many grants given?
Yes. So the 27 awards that were made this year in fiscal year 18-19 were truly supported by the licensure renewal fees of both the Board of Psychology and the Board of Behavioral Sciences. And it's different from fiscal year 17-18 where we made 60 awards because we, on top of the licensure renewal fees, we also received a grant from Kaiser, and that community benefit supported the other additional awards.
Not receive the same grant the following year?
Mhm.
Okay, thanks.
Then on the next page, where it states as of August 1st, 2019, the fund balance for the Mental Health Practitioner Education Fund as a result of the increased licensure fee contribution is $951,558. The licensure fees currently reported from the Board of Psychology as they are transferred to the foundation and to the Office of Statewide Health Planning and Development is $174,520. I did receive an update from our department, and as of earlier this week, as they closed out their accounting for fiscal year 18-19, we did receive from the board $192,030, and that's representing the monies that have been transferred to the department through May 2019. And so as the department receives the funds, we will have an updated figure.
And just for clarification, I know we've talked about this, I think, in prior years, but for the board members' benefit, and just for clarification, the two funds for our board and the Board of Behavioral Sciences are administered separately.
Correct.
In other words, it's not a combined fund that is administered. The awardees are granted from each separate fund. Is that correct?
Correct.
Okay.
So I like to think of it as it is one fund, but it's separate in that we consider the ratio and the dollars collected per licensure board. So it's solely based off of the funding collected by each board, and that's how we determine awards instead of lumping them, all the professions together.
Well, this isn't a question for you. I'm just curious, how many people get their licenses every year as psychologists? License
You're asking
person.
Ms. Chung?
I'm asking Ms. Chung. How many people get licensed or relicensed, newly licensed or relicensed as psychologists every year?
Newly licensed, I think from my recollection from the licensing report materials, the attachment, I think we have about 200 new licensed psychologists increased since April. Like, I cannot tell the number every year because it varies, but I can definitely. I think if it's because it really fluctuates each month, I would say roughly about I want to say like around 1,000 because that's the amount of application that we received on average. But I can't tell for sure without really looking at it because then I don't want to just throw a number out there.
But that gives me a rough figure. And that's every year we're talking about, or every month. What do you?
Like from I can certain the numbers from April to July is about 200. That's for sure because that was reported.
And that's new licensees?
New licensees.
And what about renewals?
Renewals, I cannot tell that number. Maybe I have to defer to Central Services on the renewals number.
Okay.
If that, but we can definitely go back. And
No, I'm just curious how much money basically we have at $20 per license every year. So I was just trying to figure that out.
I would want to clarify that the renewal is the only time you're paying that $20 fee.
Okay.
So you're not paying that with your initial license.
Okay,
So that is
so-
only upon renewal. And I
Okay.
think around 9,000 to 10.5 per year. It fluctuates, even
Okay,
years versus
renewals.
odd years. Yeah.
Okay.
So because everyone is on a biennial renewal, meaning you renew every 2 years as a psychologist, it kind of fluctuates.
Okay.
So if I remember right from looking at budgetary issues, 1 year is about 1,000 less, give or change. So
Okay. Thank you. Thanks, y'all.
And just so we're all clear, so the $20 for renewal, each time people have to renew every 2 years, that $20 goes into a portion of the fund that's allocated to psychologists. So the money that psychologists pay in is the money that gets paid out to psychologists.
Correct.
Similarly, the money gets paid in by BBS is the money that gets paid out to BBS licensees.
Correct.
Okay, thanks.
Thank you for coming to share the information with us. Just a couple of quick questions. You told us that LMH eligible sites were publicly funded or mental health facilities. Does that include school settings, colleges and colleges or universities that might be in rural areas? Does it include that are publicly funded?
Yes,
Does it
that
include
would-
those types of settings?
Yes, we've had some of those providers working in those settings, and they have applied to the program. Yes, those would be eligible.
And I'm also curious about how do practitioners learn about the fund so that they can apply? Whether they're BBS licensed or licensed through our board.
So that's something that we've partnered with the Board of Psychology in featuring this information on their website and sharing our email communications with licensees, featuring the program in the newsletters, also partnering with the employers, these community clinics that employ these individuals, and we're working to create more of a robust outreach campaign, and also ensuring that those folks that are getting the email communication, that they also receive notices when they are on social media as well.
And also, we include a little flyer that was provided by the fund to all our licensees at the time of their renewal. It says how to apply, and then it also says on the back how to contribute additional funds.
Thank you.
Mm-hmm.
Thank you. So for fiscal year 2019-2020, this fiscal year, to account for the additional renewal fees that were collected from the $10 to $20 increase, HPEF has an allocation to spend $661,000 to award applicants in the LMH program. So the licensure, the increased licensure fees were collected now July 2018. The collection began in this past budget, this past governor's budget for 1920. We did, as an organization, have to submit a budget change proposal to increase the spending allocation as a result of the increased licensure fees. So I just want to clarify, yes, it looks as though we didn't award as many individuals in 1819 because we needed to go through a budget change proposal process to increase the spending allocation. So the plan for this fiscal year, because of the increased spending allocation, we estimate to have 44 awardees. And then on the next page, I included one of our recipients, Dr. Frederick Hives II. He was featured in the Board of Psychology newsletter, and it's just a testament of the impact that the award has made. He is practicing as a neuropsychologist, but because of his interest in mental health, the financial relief has contributed to his passion and dedication to serving the underserved. So I just wanted to share that with you all. We had another recipient as well, so you can take an opportunity to read that. We do have an open application cycle. Currently, it opened on August 1st. The deadline to apply is October 8th. All our applications are done online using the link below. As I mentioned earlier, awardees or applicants can receive the award up to 3 times. Please visit our website for more information on this program at thehealthprofessions.ca.gov website. I did also want to mention what's additional criteria, additional funding that we received out of the governor's budget. The governor's budget did include $46 million in general fund to support existing mental health programs. As I mentioned, there was about 500 individuals that were eligible but not funded. Our plan with this general fund revenue, which we have 5 years to spend, is to award these individuals that were eligible but did not receive an award with this new funding. And of the 46 million, there is 1 million of that amount that's dedicated to award licensed mental health providers that were former foster youth, and those providers include licensed marriage family therapists, social workers, and clinical counselors. So because of the new budget, there was language that included to award former foster youth in those specific professions.
Wait, I'm sorry.
Yes.
Can you go back? So this is specific to foster youth? What was that again?
Yes. So the governor's budget allocated the $46 million in general fund, and of that amount, $1 million is designated to award licensed mental health providers that were former foster youth.
Oh, great.
Yeah.
Oh, good. Thanks.
And that includes psychologists who were also?
No, it did not. The legislation did not include psychologists.
So are we talking like MFTs, LCSWs?
Yeah, MFTs, social workers, and then licensed professional clinical counselors would be eligible that were former foster youth.
Do you have any idea why psychologists weren't included in that?
I don't.
Thank you.
The $15,000, is that statutorily set or is that established by the agency?
Oh, the $15,000 for
as the award.
For the award,
Mm-hmm.
I believe that was structured in our regulations to award up to $15,000.
And has since establishment of that $15,000, is it reviewed on a CPI basis or a landscape analysis with the cost of education, and tying that in any way to the amount of the award in general?
Yeah, I think the organization is seeking to look at that because of the cost of education, to have the flexibility within regs that you are awarding these awards, but because of the influx to have the flexibility to increase the award if possible. Yeah.
And then you mentioned that with the $46 million that was included in the recently adopted budget,
yes,
it would go to the 500 or so folks who were eligible but did not receive a grant.
That is our plan.
And,
yeah.
And so the absent that allocation of $46 million in any other given year, for applicants who were eligible but did not receive a grant, what is their recourse or what's their next opportunity, if you will? Or are they given priority at the next application cycle if they didn't receive it the first time?
Yeah. So for every application cycle, for those that aren't awarded, they are encouraged to apply again, and it's we look at these applications on an annual basis, so we're not holding these applications, and we wouldn't be prioritizing them, but we encourage them to apply through our online portal. Yeah.
Thank you so much.
Yeah, thank you.
So another question. I had another question. Oh, yeah, just to follow up on what you were discussing with Mr. Fu.
Yeah.
Just in terms of the education for psychologists is way more than the
Definitely.
education for, say, a social worker or marriage and family therapist. And yet it's the same amount, maximum amount for both. So I just think it would be probably really a good idea to take a look at restructuring,
Yeah.
some payments. So I really would like to support that.
Great. Yeah, definitely. I think that's
Yeah.
something that our organization is seeking to look at, and as a means to mitigate that educational loan debt.
That's great. As I look at this, I'm just doing the numbers. It looks like everybody getting the maximum amount, the psychologist getting the maximum amount, given how many renewals we have a year, that would be roughly 12 psychologists a year could get it. And that would be the maximum amount.
Yes.
Yeah. So, thanks.
So I have a question with regards to the award. So is the award provided to the applicant or the awardee, or does it go to the lending institution?
It goes directly to the awardee.
To the awardee. Okay.
Yes. And then the award, so they'll be allotted the $15,000 award if they're awarded the maximum amount, and that's divided by the 2-year service obligation. So once they complete their first year, then they'll get payment in arrears.
I just want to say I think this is a great thing. I'm really glad it's happening. I do think it's really helpful to get practitioners in these, to serve in underserved areas or with underserved populations. So I'm really glad that we're doing that.
Yeah. And I appreciate the board's support and the support of the licensees, and it's just the continuous partnership and communication to spread the word and to spread the word to those providers that are working with vulnerable populations, that they are applying and hopefully receiving an award for their investment.
And just for the benefit of the board members, there was a time, I think it was, you said 2016, when we ran the numbers on licensed psychologists by allocation by county, and that there was actually one county that had 0 psychologists, and there was one county that had 1 psychologist. So again, this is a concern beyond historically underserved populations, also historically underserved communities.
Correct.
Where we want to have psychologists available to all Californians, if at all possible.
Definitely. Well, thank you for the opportunity to present, and I look forward to providing more updates.
Beyond any board comments, are there any public comments or questions relative to this program?
I'm Dr. Jill Lindercrow, I'm the CEO at the California Psychological Association. I just had a couple of questions. So did I understand you correctly to say that this is a 501c3 organization? But I'm not quite understanding, it's a 501c3 organization within the state of California's structure?
Correct.
So your finances are governed by the state of California?
Yes, we go through the legislative budget process.
Okay. And do you have your own board?
Yes, we have a board of trustees comprised of 13 members.
And who are those people typically?
Those are, some of them are members that are appointed by the governor's office, as well as the Senate Pro Tem and the Senate Rules Committee speaker. Assembly Rules Committee speaker.
So they're appointed positions. Yes. And then when you make the awards, who decides on who gets the awards? What kind of review process do you have?
We have a selection committee, and that's comprised of our board members and also those that are experts in the field from educational institutions and professional associations, and some board members from the licensure boards.
Okay. How would one go about expressing interest in that
You
process?
can contact me directly, and we'll share an application with you, and we can have you join the committee.
Okay. And then just one other question, because do you happen to know, you said it was through a piece of legislation, that the $1 million for previous foster care youth who are mental health professionals, do you happen to know what legislation that was? Because I am also surprised that psychologists weren't included in
I
that.
don't know the specific bill. It was through I
Trailer
don't-
bill
Yeah,
language.
yeah, I don't know.
It was what?
The
Trailer bill is either budget. It was probably trailer bill language for implementing the budget that was adopted.
and I don't have that.
Okay.
Yeah, this was already included at the time that program was looped in, that this was going to be
Okay.
funded.
Okay, I'll have to do a little research on that. Thank you.
But just so I'm clear, for that $1 million where a psychologist was not included,
Correct.
that was as a result of statutory language.
Yeah, it was in the budget, and as Board Member Fu mentioned, the trailer bill language.
Okay, thanks.
It's a one-time allocation too because of the surplus in this recent year, and it's not
Correct.
ongoing as well.
Yes, that's correct. Okay.
Any more public comment or board questions or concerns? Thank you so much for coming.
you.
I know we really grilled you today.
No, it's okay. I had a meeting with the Board of Registered Nursing, and they did the same. So
Okay.
I'm used to it.
That's
You know,
But
we're doing good work, so I appreciate your support, and hoping that we can do more to support these areas of the state.
And I think I can speak on behalf of the board members and board staff when I say we think this is a very important program, and we really appreciate being brought up to date on it.
Yes, you're welcome. Thank you.
Thank you. Okay, so we want to continue on into the licensing committee report, and as I understand it, Dr. Horn has agreed to start to get through some of this material. Then we will break for lunch, and we'll probably complete the licensing committee report after the lunch break. And we appreciate your cooperation and flexibility in that regard. So the licensing committee report, I will turn it over to you, Dr. Horn.
Okay, thank you, Dr. Phillips. I can't remember how to do this. Let's start with 21A. It had been brought to our attention that there was some confusion by the public about licensed educational psychologists that are licensed by the Board of Behavioral Sciences, and then licensed psychologists, what do they do, what's their scope of practice, and I think so that was one thing. And then the other thing was about working with certain populations, and some confusion about what are, well, I guess scope of practice covers it, but what are licensed educational psychologists allowed to do, and where are they allowed to do it, and what are they allowed to do with those populations? So I think that probably, would you all say that covers the, so go ahead.
Since I'm one of the most confused board members on this particular topic, there's also a category called school psychologists who are credentialed, as I understand it, by the Department of Education.
Well, yeah, but that's a different thing. School psychologists who are licensed to practice independently are outside of the school setting are licensed educational psychologists.
So sometimes a licensed educational psychologist is a school psychologist, and some people that call themselves school psychologists are not licensed educational psychologists.
Correct. They only practice within the schools.
Didn't they tell us that in order to become a licensed educational psychologist, you have to first be a school psychologist?
Most of the licensed educational psychologists are school psychologists.
I
yes.
thought they had said even to qualify or apply or whatever to be the LEPs, you had to first at least qualify as a school psychologist.
They might have. I don't know. I might have missed that.
It was,
part.
yeah.
I know that all their LEPs are school psychologists. Yeah.
Yeah, that's
but
how I heard
didn't
it
know
too.
that was all that was in that category.
Yeah.
But anyway, so
I can add to that
Yeah.
if
Okay.
for
Of course.
information. So LEP, they're licensed by the Board of Behavioral Sciences, and then LEP obviously they're independent practitioners, so they can practice anywhere they would like, and when LEP work in school settings, so most of these folks probably also credentialed by the teacher commissions on teacher credentialing, and then they will call themselves as school psychologists
Right.
because that's the settings that they work to provide services regarding education access to school individuals. So that was also provided in the presentation
Right,
as well.
thank you.
But to be, just so I'm clear, because I get so confused, to be a school psychologist, you do not necessarily have to be an LEP, a licensed educational psychologist.
So from our understanding, and I think when in the September licensing committee meeting, when the teacher commissions on teachers credentialing able to come to present to us and let them know about actually the population that they credentialed are called pupil services personnel. So then we'll get more clarity on who they are and
Whether
what
they're-
they call themselves
Okay.
when they work in school if they're credentialed.
Yeah, and it does say in there, the thing that they shared with us, all LEPs are or were school psychologists.
Okay.
Yeah.
Thank you. So part of it's a setting. I mean, like Ms. Chung said, if they're licensed educational psychologists, they can work independently and they can work outside of the school setting. But anyway, so we had this presentation at the licensing committee meeting, and I'll say it was kind of, basically they had I think the president of the, was it the board? Of their board, Board of Behavioral Sciences, who was a licensed educational psychologist, and talked to us about the scope of practice for LEPs. And y'all can read it here. I mean, basically, she said it's a very focused practice. They don't consider it psychotherapy. They focus on educational needs of children, basically, or people who are going to school, school-aged folks, so that they can have better, they can provide for them, or the assessments that they do or counseling that they do can help them succeed in the in an educational environment. There was some public comments from there were some public comments from psychologists who work at regional centers, I think they were, with children who are on the autism spectrum, expressing some concern about what licensed educational psychologists might be doing, and particularly in terms of diagnosing autism. And but they explained to us that basically their scope of practice is to focus anything they do on the educational experiences and making those educational experiences better. Would y'all agree? But we are going to have these in our next licensing committee meeting in September 24th. We're going to have people from teacher credentialing to talk to us about those different kinds of things. Because again, to the public, that somebody's called a psychologist, these fine distinctions don't necessarily hold. So, or they don't necessarily understand those fine distinctions. So there's no action at this point in time. We're still looking at this and kind of trying to wrap our heads around it and see if it's a public protection issue and if these raise public protection issues. That's where we are right now.
Oh, okay. I just asked.
They seemed a bit unclear also about the history of it and how it's playing out today. And the people from Regional Center said that there was overlap that they were concerned about and how that was affecting the public. So that was very clearly expressed.
And I have a quick question. So are these the school psychologists the ones that would run those educational plans on the students and things like that? That they assess those?
You're
They
referring to
could be.
IEPs?
They could be.
They could be.
Independent educational plans, IEPs, yes.
Oh, right.
Yeah.
Yeah.
Mm-hmm.
But these people, the LEPs, are like a step further
They're
than that.
licensed, so they practice,
Yeah.
can practice outside of the school.
So they can have their own office.
They can be an independent practice.
Oh.
Yeah.
And can they bill independently as well?
Mm-hmm. They're a licensed professional.
So when we ask the question, if someone comes to you in your independent practice and say wants some testing done, but then, it would make sense that person could then ask them about more general psychotherapy related issues. They said that they would refer to a therapist, but they weren't particularly clear, right? Would you say, Dr. Horn? They weren't
I
particularly
agree.
clear.
Yeah, yeah.
That's very concerning to me, especially in underserved populations where we use the word, psicóloga in Spanish it's a very universal word.
I have a lot of, I think, questions with regards to this and experience with regards things that I've observed in my own practice. So my issue here that I think would be more in the realm of public protection is when they rule out disorders that and not refer them out to psychologists for a proper clinical diagnosis, because I understand that their scope, they can use the DSM to provide a diagnosis, but in the regulation, it's supposed to be within the academic process. So I've seen reports from school psychologists and LEPs that very clearly state that on their report that this is for educational purposes only. They go so far as to say it's autistic-like behaviors that require educational supports and not really giving ASD as a autism spectrum disorder as a diagnosis, and I appreciate that. And even that, some families may confuse. But what I have a problem with is I see families come to me when they're 10 years old or 16 or 18, and they tell me that a psychologist already ruled out autism. And it's someone who's really truly meets criteria for autism. They don't get services. With autism, early intervention is very important. So that's 10 years that someone that has autism never got services because the families may have misinterpreted that when they said they don't meet educational criteria for autism, doesn't mean they don't have autism. Or, I don't think that they have that training to differentially diagnose autism, to rule it out and not refer, I think is egregious. And we see it all the time.
Well, I would like to say that here we were professionals on the committee and we're asking questions to try to understand what is it that you actually do and where do you draw the line. And we were unclear. They were unclear. So when you think about the consumers coming to them, how unclear they must be. And that was alarming.
I just want to add in considering the profession of licensed educational psychologists in a school setting, they're also generally protected employees. And there may be variation district by district in how those positions are used in the school setting. And I think as this continues to be explored, it's just something to consider about what that might look like. Because if the regs are unclear, there may be even more variation. where I live in Los Angeles County, school districts are small. They have maybe 10 schools. They might have only a handful of individuals, and they might not be in a reporting line to a licensed psychologist, like one of our licensees, or there might be a senior person who oversees their work. It can vary so much district by district. So just wanted to elevate that.
Just to add on real quickly to that, if I recall the discussion, it was more of the private practice LAP scenarios than the LAPs currently in school settings. And in particular, and to Dr. Kasuga's point, the part of the conversation revolved around LAPs in private practice seeking contracts from the regional centers to do that, and that there was some discussion about whether or not they would be eligible to do what you've just described, Dr. Kasuga, in that setting. And so, and I think that's how this conversation, as noted in the memo, relating to having clarification from the Association of School Psychologists came about, was in that it was not necessarily in the school setting, but in the regional center setting. And I'm curious, for our September 24th meeting, is that where we will receive as a committee an update on whether or not the Association of School Psychologists has been approached, and if so, what's the response to a suggestion regarding a formal written statement drafted to clarify the role of LEPs? So,
I mean, I think that's a great question. I think we need to follow up on that to make sure, because she did offer to do that, and we said we would like that. So let's kind of let her know when our meeting's going to be.
And I do want to say, within the context of this discussion, both Ms. Madsen and Ms. Connolly were absolutely wonderful and so gracious with their time and coming to talk to us at the committee, and really appreciate their efforts to do that, to have this conversation, and to even offer approaching the association for that. So wanted to just make sure we stated that as we think about the follow-up process.
I just want to add, in looking at the materials that were presented, and of course I wasn't there for the presentation, so I didn't hear it exactly, even looking at where they set out facts about licensed educational psychology practice, which would be page 291 of the combined package. Item number E says providing psychological counseling for individuals, groups, and families. So beyond the question of testing, beyond the question of diagnosis, how are they creating boundaries around that process so it's only focused on academic processes? It's similar in my mind to some of the things we see with some other categories of licensing or registration. I think of people that are certified alcohol and drug counselors sometimes don't necessarily, and I'm not indicting any particular organization or licensing board, don't necessarily prescribe their services to only alcohol and drug dependency counseling. Suddenly it becomes something that much more closely resembles the practice of psychotherapy. So I think there's a larger issue here, which is how we are defining psychotherapy and the professions that are allowed to do psychotherapy. Because to the average consumer, they do not make a distinction between psychological counseling and psychotherapy. And oftentimes in my psychology practice, my clients refer to me as doing counseling with them, which is actually a distinct function in some ways from doing psychotherapy. So, I think as this discussion evolves, I think we want to also keep an eye on that psychotherapy piece to make sure that everyone's really clear about what the scope of practice is.
My issue is you can really qualify anything as academic process. If you're a school-age person that has schizophrenia or childhood schizophrenia or bipolar disorder, it's going to affect your ability to participate in the school. But that doesn't mean that they're the best people to kind of diagnose those disorders. And I think that we should talk to the other boards with regards just making sure that there's a proper referral process. Otherwise, like they're going beyond their scope really. And that's kind of like what I hope that this process would lead into, like a way to kind of like, work together with other boards to make sure that they're staying within their scope. I know we cannot tell them what to do with regards to their own boards, but like I'm just thinking of it from our own board and making sure that our consumers are not caught in, caught in the midst of this. Because I can tell you, like, if you were misdiagnosed with autism at age 5 and you don't get any services, they're not going to complain until they find out, like when they're 18, that they were given the wrong information by like an LEP, let's say. And like at that point the damage has been done to like our consumer. And at that point, like if they make a complaint about whoever that person is, it's I think too late at that point. So if we can do something to make sure that that doesn't even happen in the first place, to like have proper referrals, or else we can go after people that are not referring out stuff, then I think that's more of like a crossover with like enforcement.
See, I think that their scope, as identified in this piece we have here from the Business and Professions Code, is so broad that there's really a need for education, and who takes that role on education, on the differences, and where the boundaries should be. I don't know if there's a role for us, or who might do it, but I in my mind, that's where I think, because I don't think we're going to be able to limit their scope, particularly as defined in the code.
Yes.
I defer to our chair and to our board president and executive officer on this, but I think it sounds like based on our September meeting, I wonder if it would be appropriate at some future board meeting to have a presentation to the full board from LEPs. I'm not sure if that's something that is the desire of the committee as a whole, but I'm just hearing questions from all of our members, both public and licensed. And so I wonder if that would be appropriate and if amenable to our colleagues at BBS on that as well.
It might, since we had the Board of Behavioral Sciences come and kind of present from a board perspective, it might be good to have the association come instead, if they're the ones that are setting the practice standards, similar to how APA sets the ethical standards for practice for psychologists. That might be, if they're the ones changing the guidelines and providing the input on scope, that might be a more relevant audience. And I was just speaking to Ms. Marks about perhaps engaging, and I'm not sure when this could happen, but it seems like this discussion is ripe for some kind of consumer brochure or something that is a joint effort by the Commission on Teacher Credentialing, our board, and the Board of Behavioral Sciences, to be aimed at consumers, so that consumers kind of know, if you have a question about this is the provider that you want to go to, or if you need further clarification on X, this is the board or the provider you want to follow up with. Just so I think the big losers here are the consumers that are unclear on who does what, and we're not even sure who does what. So I think that's it's a two-part discussion, sounds like.
So actually, I was going to suggest that same thing. Prior to making it a big, this is what I'd like to see. I'd like it to come back. Let's go ahead and do what we were going to do at the licensing committee. Let's kind of think about this in that way and make a recommendation to the board. And if the board wants, additional, more information or additional people to come before them, because I do think this requires an educational process, and I think it has to be a combined educational process. And but I think that would be way to go, if that's all right.
And for the benefit of consumers. It sounds
Yeah.
like it's not only an educational process for the consumers.
Yeah.
But for
It's an educational
field-
process for the licensees and people with
Absolutely,
certificates.
absolutely.
So that everybody knows which lane to stay in.
And I would even include school PK-12 officials who employ.
So school administrators.
That's a
yeah.
great idea too. Yeah. Okay. All right, well, that was. Okay, let's do the, oh, I'm sorry, yes, okay, so that was, is there any public comment? Dr. Winkleman.
Hi, Elizabeth Winkleman, California Psychological Association. So yeah, I think it's a really confusing area, and I appreciate this discussion. One thing that I'm certain that the consumers are confused about that, and they're even confused about other behavioral health professionals and the other master's level behavioral health professionals. I'd be interested in finding out if the committee and the board would inquire about how are the LEPs trained in terms of differential diagnosis, and what are their policies for referring out. So on the consumer side, there's the education that was mentioned also about the LEPs, but I'm wondering now, what are their practices, and could those practices be improved? Could the psychology board help to improve those practices? But first ask them, because this is a longstanding profession, and looking at, especially with what Dr. Kasuga is reporting, like maybe there's ways to help improve and inform when a referral is needed, or what their policies are, how they describe themselves.
So if you'll look on page 290 of the, where it talks about licensure requirements of LEPs, the master's degree can be in psychology, educational psychology, school psychology, or counseling and guidance. So, there's not just one program that leads to it, and I think how they are trained would probably be pretty variable, depending on the kind of program that they went to. But I think those are important things, to really clarify. And again, I think if we can clarify, here's what a psychologist does, here's what the licensed educational psychologist, here's when it would be appropriate to ask a psychologist to come in or assess or something like that. So. But clearly we need more information about what's going on, and it is very confusing. So.
Dr. Schaefer, I would hope in the consideration of this that the board would contemplate that any degree or any profession that has the word psychologist in it should be considered to be under the auspices of the Board of Psychology. Regardless of how many years something has happened in a different way, it doesn't make it necessarily a good idea, just such as other entities that we know have existed for a long time parallel to the BOP, where it wasn't, beneficial. To your point, Doctor, about the testing, in my area where we have our practice, and one of our psychologists is an autism specialist, what we've seen in our area are folks with these kinds of degrees setting up private practices and then doing psychotherapy with the family after they do assessment. In no report I've ever seen from them have I seen any case of anyone using ADOS, which is state-of-the-art for diagnosing autism spectrum. And what I do see are, through observation, it was determined which is the least helpful for that kind of serious diagnosis in getting early treatment and intervention. So I do think this is a caveat emptor, yet we have an uneducated population in terms of the consumer to know the difference, so they can't even beware because they're not sure what to beware of. So thank you for the work that you're doing on that.
Okay, well, I think the next one will go fast, so we can.
And then we'll take a lunch break after the next
one. Okay. Thank you,
For everyone's
everybody,
bathrooming
for
needs.
your comments, and we're continuing to look at this, and it's obviously a big issue here. 21B, foreign degree evaluation services. So we've reported on this before. Let me see where we are here. I got to find it on my thing.
294.
Thank you. Oh, there is? On page 294 is what we did. Is it paper hand carry? Yeah. Attachment 21BA. Attachment A. Okay, so y'all will remember that at the at the last board meeting, we talked about having had these services that evaluate foreign degrees, and we had been using only in our regulations NACES, a NACES organization. What we learned at our January licensing committee meeting is that NACES actually does, depending on the organization and depending on what the applicant for licensure requests, it can be a very thorough evaluation of their foreign credentials or a not so thorough evaluation of their foreign credentials. And upon learning that, and then also we were approached by the National Register of Health Service Psychologists, who also evaluate foreign trained applicants' degrees. We decided that we wanted to change our regulations to allow, and the board voted on this, to approve the National Register as an evaluator of foreign trained applicants, and also to specify what we needed in the materials that we got as a board, because basically we want, if it's a NACES organization, we want to make sure that that NACES organization is doing the level of evaluation that we would want to see. So the board approved that, and we asked staff to bring back language that would incorporate both of those. And you see that language in the hand carry item. I'm looking at Ms. Chung, and she's shaking her head, so I'm on a good path here. Attachment A for 21B. And you'll look at the underlined, our regulations were changed. Did I take yours? We've crossed, let's see, we have two of them, right? They're both 21A. You want to tell me? I mean 21B, attachment A, and 21B, attachment B. That's what I mean. Okay. So, now what's attachment B here? Oh, one shows the marks and one doesn't. Okay, it's the same thing. Sorry. Huh? Yeah. So in 21A, we've crossed out language, added language, and if you'll look at 4 in parentheses, we said, you'll just see the changes there. The degree shall be evaluated by a foreign credential evaluation services, a member of NACES, or by the National Register. The evaluation shall, and now we're saying what we want in the evaluation and specifying it. And we also said that we want the evaluation submitted directly to the board by NACES or the National Register, the NACES organization or the National Register. And because that hadn't been the case before, the applicant was sending in the materials before. So that is our change. That's what we're recommending that the board accept. So I'd like to move that the board accept this language, this new language for evaluating credentials of foreign trained applicants for licensure.
Madam Chair?
Yes.
Could we amend your motion to also direct staff to seek legislation as a part of that adoption of the amendment language?
Yes. Yes.
I mean, we could adopt the language and just let it sit, but.
No, thank you. Yeah.
And so I'll second that if you're amenable to that amendment to your motion.
I'm amenable to it. Yes, thanks. Okay, is there any board discussion about this?
Just a quick question for staff. So right now, it looks like we are potentially have 2 bills related to voluntary surrender and related to, what was the other one that didn't make it into the omnibus? The temporary practice. And then there's the potential technician bill that that the association is leading on, and then this would be a third bill that the board would be potentially directly sponsoring. So 3 sponsored bills plus 1 of interest. What's the historic? Just from my perspective, like I've seen, we do maybe 1 or 2 sponsored bills. What's the staff capacity to potentially manage a 3-bill process, or is that going to be a sunset issue where we just wrap it into the sunset process?
I think you just answered your own question, Mr. Fu. As much as the board can put in its sunset, as far as the voluntary surrender, the temporary practice, as well as if the board likes this language on the foreign degree evaluation. I think those are the kinds of issues that aren't too crazy to ask the committee to consider for sunset inclusion. And then I was trying to think, there wasn't, and then we have pathways. So there are some additional pathways language that is non-substantive that we can also ask be incorporated. But that would be ideally, in an ideal world, we would have our sunset bill, which would have those 3 provisions: the foreign degree, voluntary surrender, temporary practice, and then the substantive kind of controversial changes that were identified in the pathways discussion would be a separate bill, so that we would just have 2 bills, which we've done in the past, either 1 bill or in a sunset year, 2 bill.
That's really helpful. I'm just trying to be mindful of the fact that as we are very active in a very good way, that we have the capacity to manage 3+ or more bills depending on it. And it sounds like we're in a good year with sunset review to wrap some of those in that process. So thank you for that clarification.
Any other board discussion about this?
Any more facial reaction from Ms. Burns?
Any public comment about this?
I just had one question for you, Dr. Horn.
Sure.
I don't recall from the presentation whether there's a discussion about the standards, if any, for the transcription of the degree for either a NACY's member, or we had discussed that, didn't we?
Ms. Song has reached out to NACY's and just kind of inquiry on that issue regarding translated transcripts. So their response is that some members do provide that service. So they are saying that they seem to believe that it will be a non-issue to get a translated transcript as part of the evaluation.
Well, so NACY says it's a non-issue to get a translation.
Yeah, they're saying that there's no limit in getting a translation of the transcript as long as the applicant is able to provide them with the official record.
So my question is, are there any standards for that transcription, either from a NACY's member or by the National Register? Do you know whether or not it's
that
from a
part
certified translator or whether the applicant, the student is providing their own translation?
We can follow up with them regarding that concern, and then we can get back to the board on that if for next time.
Yeah, I'm
Or
trying
the
to
licensure.
remember, that would be good.
Mm-hmm.
I'm trying to remember what the National Register said.
I think he
mean,
was,
they-
he was pretty specific
Yeah.
about translation, that they actually do
They do
provide
it,
that.
yeah.
Mhm.
Mhm.
And with NACES, I guess the sense was, they have, 16 member organizations. So if you go to this particular one, you're going to get a more thorough, perhaps, evaluation, and another one might not do quite as much just based on how they're set up. And they do all subjects, whereas National Register only does psychology. And they sounded prepared, National Register sounded pretty clear about being prepared to do these translations, that they would be doing it.
And if I understand correct, Ms. Chung, so within NACES, some of the organizations, member organizations are capable of doing the translation, some of them are not. So that would mean our applicants would have to choose among the NACES agencies in order to have one that does translation.
So I'm wondering if we need to change the wording here so it's really clear that how we want that done. You know what I'm saying?
The language could suggest that you could,
Yeah.
the applicant could provide
The
us with
applicant could, yeah.
provide us with it.
Yeah.
And we really want it to come from the NACES
Yeah.
agency.
And I guess with respect to the comment about they'd have to choose a NACES member that does a translation, I guess the question is that true? Or would potentially there be NACES members who say, you provide us with a translation, and then we'll
Yes.
do
That's
the
just
evaluation,
what he
which
was
is then,
saying.
it means that there's no standard for that translation.
So it seems like we'd need more specificity in our language.
Yeah,
So
I
you
agree.
might, add in line 42, where it says, provide a transcript in English of the degree used to qualify for licensure as the
By the relevant agency.
by the agency providing the evaluation.
Write a transcript in English of the degree used to provide a transcript
Oh, provide a transcript
In English.
in English.
English as transcribed, or no, what would be the word?
Translated.
Translated by a representative of the agency used.
I think we should allow for both English or translated into English, because some of our foreign degrees are coming from countries that issue their transcripts already in English. So I think just wanted to make sure we don't accidentally forbid the United Kingdom other countries, or Singapore, other countries that do issue transcripts in English already. So making sure we include both English and language translated into English. I'm not sure what's the artful way of saying that, but I think I want to make sure we don't accidentally exclude other countries.
So I don't know how much we want to wordsmith right now. So I'm wondering if maybe this would be a good time to break for lunch. We could kind of think about some words,
Because the only other alternative would be to send it back to committee,
That's
which
right.
would further slow this
That's right.
process.
That's right.
So perhaps we will take our lunch break now and return to this subject.
Thank you.
So it is now, according to my watch, it's like 12:34. So why don't we take a break till 1:35? We're giving you an extra minute there, if I don't talk too long. And we'll be back and go back into
With
session.
some different language maybe
Okay.
by then. Okay, thanks.
Good.
So we are going to go back into session and hear from Dr. Horn.
Thank you. So when last we met, we wanted to specify a little bit more in This is 21B about foreign degree evaluation services. And so during lunch, Ms. Marks and I worked on this. And here's what we came up with. The evaluation shall, 1, provide an official transcript of the degree used to qualify for licensure. If the official transcript is not in English, an English translation completed by a certified translation service must accompany the official transcript. And then everything else is the same.
Yes.
So, can't do that again. Okay. So that. I will. Yeah. All right. Okay. Board, that's what we're requesting. Do we have to make a motion about this? I've already made the motion? Okay. Oh, because then that was to, then you said about carrying this forward, right? Yeah.
Directing staff to pursue legislation. Yep.
Okay. Sorry, I couldn't remember where in the process we were. So,
Can you just amend the motion?
yes. That's what I'd like to do. I'd like to amend the motion that I made to accept this and to include the new language.
And I'll happily second again.
Okay. With the same amendment. Okay. So it's been moved and seconded. Any more board discussion about this? Any more board discussion? Any discussion from the public about this? Oh, I saw Dr. Linda Crow moving and it was like, okay. Okay. Ms. Cochran?
Okay. Bernal?
Oh.
Oh, did we want to do?
Wait. Hold on just a second.
Oh, no, I
She
was
thought
going
you
to
had
do
a
the roll
Okay.
call.
All right. So seeing no public comment and no other board comment, yes, now let's take a vote on this. That's fine.
Sorry, I jumped the gun. Bernal? Harb Sheets?
Aye.
Fu?
Aye.
Phillips?
Aye.
I'm just playing around.
Okay.
Cervantes?
Aye.
Horn?
Aye.
Kasuga?
Aye.
Motion passes. Thank you.
Okay, next, 21C. Informational videos. These are for supervision. And if y'all, so this is just an update on that. Basically, the board agreed that we should create these videos that take a look at supervision. And we decided on 3 or 2 areas, laws and regulations, and this would be for supervisors and supervisees and frequently asked questions. And so at our September licensing committee meeting, which is September 24th, the day before on September 23rd, we're going, oh, it's the 12th and 13th? Okay, it's the second time I think I've said 24, so thanks for correcting me. I don't know what's happening September 24th, but anyway, 12th and 13th. Thanks. On the 12th, we're going to have a stakeholders meeting, and it's to get input from different folks, from trainees, from supervisors, from folks involved, from anyone who's interested in this and would like to give input on what should be included in these videos. And Solid is going to provide is going to lead the meeting. So we talked the other day and figured out kind of an organization for the meetings so that it won't just be, well, what do you think? But we can help guide, Solid can help guide the attendees at the meeting about this. I'd like to get this out to the public who might be watching and the public in here and through our webcast. The meeting will be in Sacramento on September 12th and, or 23rd. I mean, September 12th, it's going to be in Sacramento, and we're really going to look at, and we have some folks who are also experts. I know they've come and talked to the board before on supervision issues. They're licensed psychologists in California, and they plan to provide input and, you know, again, particularly folks who are involved in supervision and people who are either being, by providing the supervision or being supervised. We'd really like input about what would be helpful to include on those videos. Solid will be leading it, like I said. The next day will be the licensing committee meeting, so if y'all want to hang around for the next day, you're welcome to do that too. So, okay, any questions about that?
Just one thing to add that staff is working with the Solid unit on a survey, and I just want to put it out to Ms. Chung to talk about when that survey will go out, and even if individuals are not able to attend the stakeholder meeting, if they could provide their feedback through the survey, that would be great. Ms. Chung?
Sure. So we are coming up with a few questions. So just to get a sense of the feedback for anybody who would like to provide to us. So we're hoping to get that survey out sometimes in the next week or so. And then so it will be sent through our listserv and social media. So stay tuned.
That's great. Thank you so much. So, yeah, any public comment or?
Hi, Elizabeth Winkleman with California Psychological Association. I really want to thank you for developing these resources for supervision. There are a lot of questions that do come up about it, and there is some information on the website, but it's going to be great to have that supplemented. I wanted to say I did submit probably more than you were hoping for, some suggestions for ideas for FAQs to in response to the discussion at the licensing committee meeting. And the one question, though, that I had is I thought there was a discussion at the licensing committee meeting that in addition to doing the video, that you were considering also doing a online written FAQ, because I think that for when people have a specific question, that it could be very hard to find the answer by looking through a video, but then I didn't notice any reference to that idea of a written FAQ or any written document guidance in the item.
Yeah, we're going to do that as well. I think this was just particularly focused on what should be included in the videos. Yeah.
Great, because I think that having both would be really helpful, and yeah, and that we had discussed that the psychological assistant FAQ model is a great example of where people can find information that's really does come up a lot in terms of the frequently asked questions, and then it has the links to the regulations, and it's great, and having something similar to that I think would be really useful. But I'm glad to hear that that is still part of the plan. So.
Thanks. Any other discussion or comments or anything about this item on the agenda? Okay. All right, September 13th. Don't forget. All right, let's see where we are now. What? Thank you. I had to. All right, we're on 21D, update on the grievance process. Ms. Chung.
So at the licensing committee, that was happened in June. It was brought to the committee's attention that there's some issue regarding a process that potentially may be absent or not there yet regarding grievance. Actually, it's discrepancy between hours reported on the verification of experience form and the weekly log. So the committee has tasked staff to come up with a process, and then we'll be providing an update to maybe some of the options that we come up with for the licensing committee for their consideration in the September meeting.
Great. So just so that, yeah, y'all know, we've gotten a little, we've heard from folks that there really isn't a process that is identified that they can go through when there is a discrepancy. And that's created a number of problems when that does happen. And we want to make sure that there's a good and fair process in place to help deal with those issues. So, any board comment?
I'm just glad to hear that because as an early career psychologist, I have heard a lot about licensed applicants that had similar experiences with regards our discrepancies, and it's a big deal to be able to appeal those and not let it that prevent them from continuing the process of getting licensed. Yeah, so I'm glad.
Yeah, good. Any public comment about that?
Hi, yes. I also thought that at the committee that was a discussion was a little bit broader than just the verification of experience hours. Because I recall that there was somebody who had felt harassed by her supervisor and that she felt that she had no recourse. And so I was wondering, again, this item says that it's only regarding the discrepancy with the log, but I'm hoping that the board would consider looking at a broader grievance process because the trainees feel very stuck if their only option is to report the supervisor to the board in terms of a formal complaint. They feel they're going to be retaliated against, or it may result in they wouldn't get their hours, or that if there is any other additional process that the board could provide to consider that.
Yes, thank you, Dr. Winkleman. I do remember that discussion, and I believe that we have put that, because the minutes is not approved yet, so I remember that it was put forward for a future meeting on the agenda for discussion. So definitely this is something on our radar.
Great.
So I think we saw it as a bigger issue. So this is the piece right now that we can go on and work on, but we saw this other as a bigger issue that we want to discuss in licensing committee and then bring back to the board. Okay.
Great, that'd be great.
Since I'm no longer on licensing committee, I just did want to mention, there are areas in which we should appropriately mediate things like verification of experience, et cetera, et cetera. I don't think we should make ourselves the last stop for people that are having disputes with their supervisors. So I think we have to be careful what roles we assume and what roles we don't assume. But obviously, it's a delicate issue because there is a way that this can reflect on the professionalism of the supervisor and therefore is an appropriate source of an enforcement complaint. So I'm sure the licensing committee will do its typically wonderful job at sorting through those issues, but I thought I would just highlight that.
And it may go from licensing to another committee and then come to the board. But it does seem like these are bigger issues being discussed at that point in time. So, yeah.
Great, thanks.
Okay, any more public comment? Sure.
Melody Schaefer, CPA Division 2. My experience with some supervisees in larger institutions where there's many interns and supervisors, and hearing this from other supervisors, is they'll bring in the log and forget to bring in the log repeatedly until a month goes by or whatever. In my practice with postdocs, I ask them to bring the login every week, the next week, so we can go over the hours then. And what I would suggest as a possibility, if you would consider, is to have the log that each week the supervisee and the supervisor at least initial that column of the hours, and for the supervisor to keep a copy of each month after everyone signs off. I even encountered one case where I had always kept a copy, only to at the end have a supervisee bring in the original, because they keep the original, as you know, and had crossed off numbers and changed them. And luckily I had my copy, and I says, I have the copy of what we signed. And so and that was done right at the time after that full month was done. So these numbers could not be, wrong in here. So of course it was fine after showing that, but I don't know that that's part of what supervisors are told to do. And it's kind of one of those things that until there's a problem, then it's, I could have had a V8. So maybe that could be the processes to sign off each week. So quick discrepancies are rectified, and then to maintain a copy so that if there's anything that looks curious, that there's that kept in good stead.
That's
Thank you.
a great idea for best practices in supervision, and so that's a great suggestion. Thanks. Any other comment about this issue? All right, that was just for board and public information. So, all righty, next item. The 21E, the licensing committee's revised name and goal memo. We'll see if this has the fate of the outreach and education. So, and communication. Yeah. So at the last licensing committee meeting, we thought about our name as well. And we considered what the current licensing committee does. And we thought it really wasn't totally licensing. It was about all the things that are needed for licensure and relicensure, et cetera. So we decided or are recommending to change our name. And by the way, it's a one-word name. Exactly. I'm just saying. to the licensure committee versus the licensing committee. We felt that would really encompass all the things that we look at with regard to maintaining the license, applying for licensure, and all that kind of stuff. And then our revised goal, which I'll have to admit we were totally helped with by Ms. Chung, Ms. Sarek, and Ms. Marks, was the goal of this committee is to create and maintain a clear and efficient framework for licensure, examination processes, and continuing professional development through the board's statutes and regulations to ensure licensees meet the qualifications necessary to practice safely and ethically. The committee communicates relevant information to its affected stakeholders. That's our goal. So let me ask, what does the board think about that?
I think it's great.
I would like to move that we adopt.
What'd you say?
I would like to move that we adopt the revised licensing committee name and goal into the board's administrative procedural manual.
I second. Oh.
Okay, so it's been moved and seconded to adopt the name change and the goal change into our administrative procedure manual. And let me ask, is there any more communication about it? Or did you need to know who moved and seconded it?
I have
Okay.
Fu for the second and Kasuga is the
Right. Okay, good.
Fu for first and Kasuga for second. That got it.
Right. Any more board discussion about this? I really want to thank all the people who gave input into that. We were kind of stuck, to tell you the truth, but y'all really helped us. Any public comment about our name or goal change? Thank you. All right, then. Seeing no further discussion, I'd like to call for the vote, please.
Bernal?
Oh, sorry.
Hmm?
Voting?
You're voting.
Yeah?
Yes. They
You
Call
started
for
to
the
say
vote?
something, yeah.
Somebody start though.
Bernal?
Kasuga.
Aye.
Cervantes.
Aye.
Fu.
Aye.
Harbsheets.
Aye.
Horn.
Aye.
Phillips.
Aye.
Motion carries.
Okay. Now, the next three require a board vote. I think it's 3. Is it 2? Okay, thanks. All right. First one is 21F. This is a licensing, a recommendation regarding a request for an extension of the 72-month registration period for a person to be a psych assistant. This person is requesting a 1-year extension of the 72-month registration period. So a 1-year extension. This person has basically at this point earned 2,000, roughly 2,000 hours of pre-doctoral supervised experience, and that was in a formal internship. Then, however, this person still hasn't completed the doctoral program because this person hasn't finished the dissertation yet, and that needs to be finished before this person has a doctorate. So even though the person at this point has 2,000 hours and has been a psych assistant for, the 72-month time allotted to be, at least in October, the person will have been a psych assistant for the 72 months allowed. This person is still in training and hasn't had a chance to accrue, like I said, the postdoc hours because the doctorate hasn't been completed. And I think there were some difficulties in completing the dissertation. Committee members changed and those kinds of things. And so it seemed like it was a process that kept trying to happen, but there were interruptions in the process. So the licensing committee is recommending that we do grant that extension to for a 1-year extension for to the 72 months so that this person can finish up the dissertation and postdoc hours the person might need. So that's our recommendation. I'd like to move that the board accept that.
I second.
Okay.
I had a quick question about it, and that was the memo was originally written said they were going to be finishing their dissertation or they're going to finish their doctorate in May, June. Now it's changed to October.
I think if
I'm looking at the
the
right
psych assistantship is up in October.
Oh, I see.
Yeah.
Okay.
So the expectation is a person did, I mean, we don't know, but that's what we think. The person has finished the dissertation and everything is okay. And so this person has a little over a year, basically, to get postdoc hours.
Okay, thank you.
Do we know, the person was projecting to finish in May or June? Do we know anything?
We haven't got an update on that from the PSB yet. I mean, psych assistant, excuse me.
Just curious.
We may find out. So, any more board discussion about this? Do we give public discussion on this? Does public have anything that they'd like to say? Did you? Okay. All right, seeing no further board discussion or discussion from the public, can we call for the vote, please? I'm sorry?
Do you had a motion and a second?
Yeah.
Sorry.
So I moved it, and Mr.
Okay.
Fu or
No,
Ms. Harp, Dr.
Dr.
Harp
Harpsheets.
Sheets seconded it. Sorry, I'll say that next time.
Move to approve or disapprove, I'm sorry.
Approve.
Okay, Bernal.
Aye.
Kasuga.
Aye.
Cervantes.
Aye.
Fu.
Aye.
Harb Sheets.
Aye.
Horn.
Aye.
Phillips.
Aye.
Motion passes.
All right, 21G. This is another, this is a request for a continuing education exemption. And, I'm sorry?
21F,
Oh, sorry.
page 306.
I got it. No, wait a minute, wait. All right. Okay, yeah, sorry, I just went to the next agenda item and not to the next. Okay, so PSB 2. See, I thought we had 3 people. That's what I was talking about. Okay, see, you got me confused. All right. This person is also requesting an extension of the 72-month registration period, and this person, let me see, remember this one. This person's psych assistantship expired in May, and submitted an extension request for a 2-year extension in May, because let me go back. This person thought his or her psych assistantship was over, and it wasn't. So, because it was this person was going by the date that we put the regs into effect, and so this person still had a couple of months left, and on the psych assistantship. So the person renewed the registration, and it was set to expire in July, or it did expire in July. Okay. And, but the licensing committee was going to have to review that request for an extension at a later meeting. So the person then revised their 2-year extension request to a 1-year extension request. Because we had delegated to staff some things that they could extend, that they could extend for up to 1 year. So this person found out that the staff could extend for up to 1 year, and that's why this person revised, from 2 years to 1 year. And this person has met all the SPE requirements, pre and postdoc hours, and basically has served 5 years or 6 years. 6 years as a psych assistant. But the reason for a psych assistant is to accrue hours. But what this person hasn't done yet is taken the EPPP or the CPLEE, and that seemed to be, that's why the extension has been requested, to take the exam. That's not the reason for this category. So the licensing committee voted, and we'd like to recommend to the board to deny the one-year request for an extension. This person's received all the hours, and it doesn't mean this person can't take the exam, and that would still need to happen before licensure, but or the exams, and those need to happen before licensure, but that this person really can't continue working under this category because she's or he has completed everything this category's for. I don't know a better way to say it.
Yeah, I would just add that the person was qualified to take the licensing exam in June of 2018 and has not made any attempts to take it yet. So it's been
Right.
some time.
That's right. So it had been a year since the person was qualified to take it and essentially okay to take it, and hasn't done that.
And as I understand it from your timeline, as of 2014, they actually had the 3,000
Yeah,
pre
they
and
had the
postdoc
3,000
hours.
hours.
And they've done another 3,400 hours.
Yeah.
So they've had lots of time.
So that's our recommendation to the board, and I'd like to move that the board accept that recommendation to deny the one-year extension request.
I second.
So it's been moved by Horn, seconded by Harb Sheets, to deny the request. And is there any board discussion about this? Okay. Any public comments or discussion about it? Seeing none, I'd like to call for the vote, please.
Bernal.
Aye.
Kasuga.
Aye.
Cervantes.
Aye.
Fu.
Aye.
Harb Sheets.
Aye.
Horn.
Aye.
Phillips.
Aye.
Motion carries.
All right, now we're on 21G, consideration of the recommendation regarding a request for a continuing education exemption. So this person, as you all know, we have approved sponsors for providing continuing education. And this person, but we have said in our regulations that we can grant an exemption if there aren't adequate continuing education credits that are continuing education that's provided by our approved sponsors in particular areas, and that would be on a case-by-case basis. So this person is seeking an exemption to what do I want to say? Because this person received continuing education hours not by one of the board-approved sponsors or one of the okayed sponsors of continuing education by the board. And so this person essentially said there was nothing in the area that was provided by one of our approved sponsoring agencies or sponsors. So, and this person attached, which y'all can see in there, the course taken and the information about the provider. And the course is a training course on nutritional and integrative medicine for mental health professionals. And essentially it's on integrated healthcare. But this is specifically with a focus on nutrition. And the licensing committee is recommending denying this request. There are a lot of courses, continuing education courses by approved providers in integrative healthcare. and that would have more of a psychology focus. And so we are suggesting or recommending that this request be denied. So I'd like to move that the board accept the licensing board's committee's recommendation to deny this request.
I just have a quick question,
Yeah.
Dr. Horn. So if it's denied, then, and it's because you said it wasn't an approved and it was more nutrition focused, sounds like, what's like the process then for this person? If
This
it's
person
denied?
can take a lot of CE courses that are given by our approved providers. This person's area is well covered in continuing education that's provided by sponsors we do approve.
Oh, okay. No, but I'm saying, but if it's denied, then do they have to go back and kind of start?
Well, they have to take the courses to make up for
Okay.
this.
Thanks.
They want to use this for their courses. So.
And this licensee has not taken the course yet. So it's our understanding that the licensee was waiting for approval. And of course, they can still take it if they would like to. It just would not count towards their CE requirement for renewal.
Okay. Okay, so I'd like to move. Did anybody second? Okay.
Second.
So moved by Horn and seconded by Harb-Sheets to deny this request. Is there any further board discussion? Mr. Fu.
Just a quick question with relation to like a CE audit. So will this, if this person happened to be audited at some point and because they were waiting for us to make the decision and for some reason they were short of it, would they be held harmless in that process because they were waiting for our approval, or is the expectation that pending approval from us, they should have been still completing their required hours for CE for those hours?
They don't renew until 2021, so they have time.
The second on that. So they should be completing those hours. So, or at least have a plan to make them up prior to their renewal.
Is there any public comment about this? Okay, seeing none, I'd like to call for the vote, please.
Bernal.
Aye.
Kasuga.
Aye.
Cervantes.
Just for clarification, the vote is to approve the recommendation by the licensing committee to deny this.
Right.
Aye.
Fu.
Aye.
Harb-Sheets.
Aye.
Horn.
Aye.
Phillips.
Aye.
Motion carries.
I just turned it off. All right, so as you know, we've been working on pathways to licensure for a while now. And the board last November approved our pathways changes. And one of the things the board approved was to rename psychological assistant psychological associate. And it was brought to the staff's attention that the word associate might be confusing to people because in some places an associate is categorized as an independent practitioner. And for reimbursement purposes, and that person can be reimbursed for services or whatever, but can practice independently. And in this, it would be, in California, this would be a category under supervision. So there was some concern that it might be misleading to the public, the name associate versus assistant. might be confusing to the public and might suggest, that this person for us would not be in a supervised category, although the person would be. So we're bringing this up to consider whether the board wants to rename this category back to psychological assistant versus psychological associate, which we decided. Now, the term psychological associate, let me remind folks, came from our stakeholders meetings, and you'll recall those. Came from our stakeholders. They also talked about the Board of Behavioral Sciences, their people in this category for MFTs and social workers are called Marriage and Family Therapy Associates, or they're called Social Work Associates. So we thought that would be consistent with our other licensing category, the other licensing, and the psychologists, I think, and trainees at our stakeholders meeting felt this made the psychologists seem in a lesser position to be called an assistant versus an associate as compared to other boards. So this was just some of the stuff that came up in our stakeholders meeting. So that was the reason that this happened. By the same token, I don't think we want to confuse the public. I'm not aware, I'm going to ask if anywhere else in our state a category associate is an independent practitioner. Do you know of that, Ms. Sark? Does anybody know of that?
So I tried to do a little bit of research, some preliminary research. So it seems like Texas and Oregon have that options. So I think Oregon, their path, I'm not very thorough with that, but it seems that they have licensed psychological associate that can be independent after practicing for certain years under supervision, but they eventually can apply to become independent. And I believe Texas also have that independent category as well, which they label.
After some number of years?
I think Texas is more liberal, and I can't recall top of my head, but they have that option for...
Texas is I know both of those are supervised practice. So it may be after a number of years.
Could be.
They can be non-supervised practice, but why would that be? I'm not sure why that would be confusing to our public. I see that it happens in some other places, and I don't know about the after X number of years, probably without any problems or something like that, then they can practice independently. They're not licensed as a psychologist. Is that what you're saying? But still called a psychological associate?
Correct.
It looks like in Oregon, that's 3 years of supervised.
Before they can apply.
Yeah, before they can apply for the independent
status.
Associate.
Okay.
So.
Okay.
And I may be incorrect about this, but I believe that it's a master's level license under a psychology board.
It is. There's a few others with some other names as well that are master's level with independent practice in other jurisdictions.
So as much as I've been an advocate for the fact that California goes its own way, we are terminally unique, I do think it creates confusion when other boards have a licensure category that's got the same title as a pre-licensure category.
For us?
Yeah. And, the term psychological assistant, at least as it relates to California, has been pretty well established for a long while. So I think if we're going to change it, we should change it to something that's not going to cause confusion with other states. And I'm certainly open to any ideas as to what people have as to an alternative, but I think given that we've learned this, I think it would probably be not to our advantage to do to change it to psychological, or to keep the psychological associate
In pathways.
in
And to
pathways.
go back to our original psych assistant.
Or to whatever other name we can come up with.
Well, we had difficulty coming
We
up with
did
another
have
name,
difficulty
so-
with it.
I mean, I think it would be back to psychological assistant. I don't think we want to delay pathways. And so I think it would probably be psych assistant. And if y'all are worried about that, because other states do that, and it would be essentially in this way more consistency, which I think is always helpful if people can look and say, oh, I know what a psychologist is, or I know what a psychological associate is, then I'm definitely in favor of whatever we can do that's provides consistency, because I think that all helps the public.
I would add that the word associate, from a business standpoint, suggests this person works here with equal standing, is part of this group with equal standing. It's a group of associates. And so I think that would be misleading to the public.
In law, that's certainly the case.
Yeah.
Yeah.
Yeah, I was going to say it.
Yeah.
So,
So y'all are okay with going back to psych assistant? Okay.
I'm sorry, Dr. Horn, and this just came, though, from those stakeholder meetings that,
Our stakeholders said associate. Staff brought this to our attention.
Okay.
So
well,
that's
actually,
why
I
it came.
think we heard about it at the ASPPB meeting too, because I remember having a discussion about it at the ASPPB meeting when people started talking about their licensing category
Right,
that was
right.
called psychological associate. It was like, oh,
Yeah.
yeah.
Dr. Horn, and actually Dr. Phillips too, since you were at the stakeholder meeting, the desire to go to psychological associate was because of a perception that assistant would convey a lack of qualifications. Was that the primary reason? I'm just looking for a refresher on why we went from assistant to associate, and I feel like that was the primary driver, but I'm curious if that actually is the correct recollection.
I think it was twofold. One was the BBS, Board of Behavioral Science, had changed over some of its categories to Associate Clinical Social Worker and MFT Associate as opposed to MFT Intern. There's also always been, I think, I can speak on from my own experience, there's always been a certain strain among people that are psychological assistants that they feel demeaned by the title. But they're often, the people that have said that to me are often the people that don't like to find it objectionable that they have to put that they have a licensed supervisor on their business card. So it is a category on the way to getting licensed, but I'm not completely sympathetic to the idea that somehow it's a devaluing title. I don't think it is necessarily. I think it's just a specific title to indicate a status.
And I think that will encourage them to be in the psych assistant category and collect their hours fast enough so they can get licensed and get the shiny title of being a licensed psychologist.
Okay, I just have to add one. This might sound pejorative, but have you ever thought of the word apprentice? Because in fact, that's probably more accurate, but it might feel pejorative.
My gut is that they would feel that was even more
Worse.
demeaning.
I think so too, but I thought I should at least say it because it's actually more accurate. When you look at synonyms, it's actually more accurate. But
do we need to then does this have to be moved and a vote taken? Okay. So, yes, we will. But I think we're going to probably get a motion on the table and then do it. How about that? Is that what we should do?
Dr.
Give
Horn,
me
may
a
I
point of
suggest
order.
a possible motion might be to authorize staff to make global changes to the pathways to licensure statutes and regulations that use the terminology psychological associate and change it back to psychological assistant.
That's a good suggestion.
And I
So
don't
moved.
think, and then we would just stay the same. I mean, we're keeping existing language, so it's not like we're Does that make sense?
Yes, it would just be unstruck and then delete the addition.
So did you move it?
So it's been moved by Mr.
I'll second it.
Fu, seconded by Dr. Kasuga, to go back through pathways to licensure, change everywhere it says psychological associate back to psychological assistant. And is there any more board discussion about this? Any public comment about this?
Joe Linder Crow with the California Psychological Association. I do want to make a few comments about this. I think the first thing I'd like to say is that your process, the whole pathways to licensure process, and all of those meetings, your care in getting stakeholder input was really well done, and you had a lot of participation. I think based on stakeholder input, you made a really good decision to change the term. I wouldn't personally use other states to set the standard for California. I'm not as familiar with Oregon, but I'm pretty familiar with Texas. They've had a troubled history over the last few years with their Title Act and with the master's level issue. And I think if we just focus on California, there are a couple of things to look at. One is that the term associate is now used for all the BBS license categories. And in the academic world, for example, the term associate professor is higher than assistant professor. So in terms of confusing the public, I think it could be very confusing to the public to have all of the master's level people be called associates and psychologists with far more education to be called assistants. So that's one thing. And that's maybe the main thing is just is in terms of achieving consistency within the state of California, that this seemed like a very good move. And this is what your stakeholders asked you. Now, I work with a board and have for a long time. And I'm always a little trouble when the board comes back and revisits an issue that was well settled. I don't know what that means when it says it was brought to the staff's opinion or attention, or the staff brought it to the board's attention. You know, who brought it to the attention? Who is concerned about this? I think we would really urge the board to stay with the original decision and change the term to psychological associate. I think it means something to psychologists to be at the same level with at least a master's level person. And I don't think it's confusing to the public. I think it's more confusing to have all of these different terms. So I hope that you will think about this for a minute more. And as I said, I wouldn't use what's going on I don't want to denigrate my colleagues in Texas or Oregon, but I wouldn't think that should play a huge role in your decision. It never has before. To go back to your point, you've never been that concerned about what's going on in other states. And I really thought this was a very forward-thinking decision after a lot of careful thought and a lot of careful conversation, and your stakeholders really bringing this forward and saying to you that they thought this was a nice and important change. So I would just ask that you kind of circle back, and maybe you'll decide not to do that, but I think it would be unfortunate at this point to go backwards and kind of move back into the old language. Because I was in a lot of those meetings, and at those stakeholders meetings, you put a lot of care and a lot of time into inviting stakeholder input. And I think you got it. And it seems to me that stakeholder input within California should weigh a bit more than maybe just having some information from what other states are doing. Because other states, many other states have a lot of confusion around their licensure, their Title Act, and I just, like I said, I'm not sure that that would be the standard that I would look toward.
Thank you.
I would agree with what Dr. Linda Crow said in several respects, and one of them was I think it was exciting to have this idea of thinking about changing it to psychological associate. However, it's not a change in the law yet. It hasn't happened yet. And I think beyond whatever input we get from stakeholders, we also have to consider the other implications and make a decision as a board as to what we think is appropriate. And I think rather than delay this process or create the confusion that would be created by staying with the psychological associate, I think it would probably be to our benefit to go back to psychological assistant at this point. So I'm still of the sentiment that it should be psychological assistant given all the parameters.
Can I ask what confusion do you think would be created by this?
My primary confusion that I was concerned about initially was hearing that it was a licensing category in other states.
Mm-hmm.
It's kind of like, if you recall back when Masters in Family Therapies were called MFCCs in California, but they had a different title in other states. I thought that was a very confusing thing, and eventually it was brought into conformity with what was generally happening in their field.
Mm-hmm.
I think it would be confusing not only for other licensing boards if they were to receive information about a psychological associate who was applying for licensing in their state. I think it's a bad idea. And I think it'll be confusing for things like insurance companies and a variety of different things that practitioners need to consider. So I have to ensure my psychological assistant, we change the category. I think it's going to there's going to be a long lag time before that gets caught up, given that those same insurance companies are probably licensed insuring people as psychological associates. So that was one of the considerations that I had personally. I was really disappointed when we were at the ASPPB conference to hear that, our mid-year meeting, to hear that other licensing authorities were already using this title for a different reason. Because I do think it would have been a nice reaction and a showing respect for our stakeholders and their concerns. But I have enough misgivings at this point that I don't feel positive about it.
Mr. Fu.
A quick question. So was the ASPBB meeting, I don't know how many P's I put in there, but was that the origin for the research, that the feedback we received during that encounter, if you will, where we learned of other training category or other categories that use the word associate in other states, and there was discussion? Was that the impetus for research, or I'm just trying to get a sense of the origin story, as we are often asking?
This was a byproduct of Dr. Phillips and myself. After the ASPBB meeting, I said, is this a concern that we are looking to renaming, and will this cause any confusion? And that was kind of your concern that you had discussed with me at the actual ASPBB meeting. So in talking with Ms. Chung after, I said, we should probably bring this back to the board, and you put together the memo, and so staff is Ms. Chung and myself as a reaction to what we heard at the mid-year meeting, and wanting just to make sure that you guys as a board still felt like that was the right term of art to use in Pathways to Licensure language.
May I ask a follow-up question? So aside from not aside, but the insurance updates and the bureaucratic's not the right word, but the changes that we need to have to healthcare across the healthcare system for this to happen, if we hold that constant for a moment, on like a business card, for example, would the change from to psychological associates would still require the person to list to post that they're that they're supervising psychologists, and that they would still be. It would be clear, at least in mediums where they're declaring themselves as a psychological associate, that they're under supervision. Is that accurate to say?
Mhm.
Right.
That's their requirement.
Yeah. And so that's I think there's an interesting tension there, because they're still required to, with the title, to identify that they're under supervision. And while I hear this comment, and yes, I know I made the motion, so let's put that aside for a moment. But to hear that from Dr. Harpsheets, the idea that associate could sometimes be seen as equal to, but I think we heard, like, in a professorial setting, associate is clearly not a full professor, right? It's someone who has not reached that level yet either. So I feel like that can go both ways as well. So I think it's been interesting. I'm just sitting with that right now.
I have a question. Dr. Phillips, can you tell me a little bit more about the concern with insurance?
Know that that's going to be a long-term concern, but I think it's initially going to create some confusion. My greater concern beyond health insurance companies, because insurance companies will accommodate it too, because they're going to want to get paid their premiums. So I'm sure they'll catch up. But I am concerned, for instance, if a consumer were to move here from Texas and somebody was a psychological associate, they might become confused, for instance, about what it is. My preference would be, if we had all the time in the world, to find some other term other than psychological associate that wouldn't be the same as the licensure category in another state, and perhaps address the stakeholders' concerns about psychological assistant. However, as Dr. Horn has pointed out, Pathways has been a very lengthy and elaborate process, and we do want to keep it moving forward in the channels it does, because it's going to require both statutory and regulatory change. So I think the cleanest thing to do is go back to the psychological assistant category. But if somebody has a brainstorm about something else, I'm open to it.
I'm sorry, can you tell me what would be the delay for what in this Pathways process? What would be the delay?
I'm going to use an analogy, and it's probably not a perfect one. Let's say 49 states, or even 2 states, said nurse practitioners could practice independently. And we decided, for some reason, as a pre-licensure category, to use the term nurse practitioner. I think it's going to engender confusion as to whether this is an independent practitioner or not. Now, true, they could look at the business card and so on and so forth, but they might operate under a misimpression. So I think rather than to go somewhere where people have already gone to make it into a independent practice category, we'd be better served either continuing with psychological assistant or finding another term that would be reactive to stakeholder concerns.
So what would be the delay, like timeline wise? Where would there be a delay?
Well,
where are we in the process of Pathways, in the Pathway process?
So where we are is the first step will be statutory changes. That will give us the authority to make the regulatory changes that the board has already identified. We will be seeking, I think there's 3 non-substantive sections we've identified that we hope we can change through the sunset process. And then all of the other sections of the statutes will be finding an author and sponsoring a bill for those changes. So that's February introduction, let's say earliest January 1, 2021 for those statutory changes. And then regulatory process is going to take us at least 3 years, 2 to 3 years to implement. So we've got quite a long process. But this term is in statute, so we would want to identify that now. And then in the regulations, the term is also repeated. So we want to make sure we start with the right one. The other option is and putting this out on the table, we keep psych assistant now, and when we go back through, I know we've discussed kind of Pathways Part 2, looking at things like quality of the supervision, looking at SPE as more of a CPD model. And this is a term that we could revisit as part of that part 2 discussion, and then taking a little extra time to getting additional feedback from insurance carriers or other states. We can send out the survey too in advance of Pathways Part 2. So I'm just throwing that out as another option. It may not be a black or white. So
if I may.
Of course.
I think, and I'm new to the board and this is my first meeting, but I like and welcome stakeholder engagement. And I think to the extent that I'm on this board, I'd like to see it honored. I am not convinced by because the process is so long anyway, I'm not swayed in favor of changing back after there was a process, and I'm presuming that research was done and that stakeholders were engaged. If the process was incomplete, then we could be honest about that and open maybe a second process or another process on the tail end to make sure that all of the stakeholders were put in. But I value the staff time, I value the stakeholders' time in getting us to this point. And I just wanted to tell you my sentiment.
So also, what if we brought this back to the September Licensing Committee meeting? It could come back to the November board meeting or October board meeting. With this taking a look at this specific term, because I feel like you do, like Dr. Linda Crow talked about, like we've talked about this, this was a good process. And I mean, I hear your concerns. I don't want to minimize them, and you know how much I am for consistency. That said, if this were the case, we should be requiring APA program accreditation for people who get licensure here, because 22 states require APA accreditation for licensure. I mean, there are a number of things so that if people look to see who are require APA accreditation for licensure. So if people are looking and they get confused, they might look here and think, psychologists in California are just like psychologists, over here in this state that require APA accreditation, or they require a formal internship, and we don't require a formal internship. And I think we're one of the very few states who don't require a formal internship. So I think there are ways that I'd much rather see, that I personally would rather see consistency, because that really does make it consistent for just a few states that might have this as a licensure category. My own, I would like to keep it at where it is. Let's come back in October with some possibilities at the, September Licensing Committee. Really flesh this out a bit and talk about it a little bit more, and we can always bring it back to the board, and that still gives us time to get everything in by January, right?
And I'm happy to withdraw the motion to facilitate that, Madam Chair.
Okay.
Just quick question there, Dr. Horton. So were other words also brought up in that stakeholder meeting, or is this pretty much like?
We didn't discuss, I don't think it occurred to any of us at the time we were having the stakeholders meetings. This term was in use anywhere else. So it was a shock when I heard at ASPPB it was. Now, if what we're looking at is 2 other boards using that term,
Right.
and it's not in common usage, so I'd really like to hear some research as to how many boards are actually using this term, some definitive research rather than, and I know it's a time-limited thing, some definitive research as to how many boards are using this term and what they're using it for. There's a difference between, in my mind, things that have historically occurred in California, like having approved graduate programs, which have been in place for a long time here, and switching to a term that's going to take us out of consistency as opposed to the historical reasons why we're inconsistent. So that's a slightly different thing. I do also have to say, Ms. Cervantes, that I think we've been very respectful of the stakeholder process in this. And one of the things we realized as a result of the stakeholder process was it was invaluable input, but there are times that the board has to make decisions that are not based just on what stakeholders want, but what is in the best interest of consumers in California. So it's a kind of a tension between wanting to hear from our stakeholders, and I think we've become much more sensitive. I think most people would agree that we've become much more sensitive to inclusion of stakeholders in our formal processes as a result of our original experience with continuing professional development. But I do think, on the other hand, we as a board independently have to decide if it's a good idea or not. I don't think we can allow that to be dictated by stakeholders.
Sure.
Hi, Elizabeth Winkleman with the California Psychological Association. I really appreciate this thoughtful discussion of this issue, and I just wanted to make a few additional points as you move forward in considering this. One is, if I understand correctly, the psych assistants in the other states, and this will come up in your research, psych associates, they may either be independently licensed or not. For the first few years, they may not be, right?
So from what I have read, they first have to be supervised, and then they can, for example, after 3 years of supervised experience and other terms stated in their regs or laws, and then they can proceed to apply for independent status. And so once granted that status, then they can practice independently.
Okay, so at least in one of those two states, the term is used for people who are under supervision. Another thing I'd like to mention is we are not consistent with other states in terms of the use of the word psychological assistant. So if research is going to be done about what terms are in use, most states, I don't think, use the term psychological assistant, and those that do, I don't believe that they have the same requirements that we do. So if we're going to look for consistency, I think it would be also important to research what states are using the word psychological assistant and in what, to signify what. Regarding the insurance companies, I participate in national discussions of national directors of professional affairs for other state associations. I've never heard of any problems with insurance companies regarding who's supervised and who's not supervised. Most insurance companies simply do not cover anyone who is not independently licensed. And in the few cases where they can be reimbursed by a third-party payer, I really doubt that this would be much of a problem.
I just to clarify, I wasn't talking about health insurance companies. I was talking about, in my case, I was talking about malpractice insurance companies. So professional liability companies have, so when I have a psychological assistant, they come under my policy. They can also get an independent policy as a psychological assistant, but I have a liability for them, so in addition, I have to pay for insurance coverage for them. So that was the thing I was referring to.
Oh, okay, I misunderstood that. But even
Sorry,
for the malpractice insurance, the person who's applying clearly has to state what their category is and whether they're licensed or not. Or whether they're under supervision. So, but I realize you also said that that wasn't your main concern. And then finally, in terms of consumer confusion, I appreciate consistency too. So anyone who knows me knows that I would really like things to be clear, and consistent. And I don't want psychologists, trainees, or consumers to be confused about what they're getting and what they're not getting. I think that, and this is, a matter of opinion, but I think it's much more likely that a consumer could be confused by an associate at the master's level in California, and they're like, oh, but my new therapist is just an assistant, but my old therapist was an associate, mental health professional. I think that that's much more likely to be confusing to a patient than somebody who might have moved from Texas or her. I think it would be extremely hard to find a consumer anywhere in the state who would be, confused by what's the title in another state. So whereas I think consistency is important, I really doubt that it'd be very hard to find a consumer who would be confused between the titles between two different states, because I simply don't think they know that. They're often confused between different types of mental health professionals in general within our own state. So, so
Dr. Winkelman,
yeah.
just so I'm curious,
Yeah.
do you know what they call this training category in other states?
I think
where people
that-
are pre-licensure and they're not independently practicing, but they're gaining the hours towards supervision?
I'd like to look into it because it's just not something
Well,
I've looked at, but
I was going to ask, maybe staff could also, I don't mean to
Mm-hmm.
overburden staff, but perhaps in the process of looking at this question, they could see what other names, because I'd be happy to have another name for it. I just don't necessarily want to create
That could
confusion.
be sent on the BARC list.
That could be,
board
that could be the
chairs
solution or a problem embedded in your answer.
I'm afraid I don't think that's going to be the solution. I wish it were. I think many states don't have any special title, that it's just in their act in their laws that they have to identify themselves as a psychological student or psychological trainee and so forth. But I think where the real consumer confusion could come here is within California, they may have seen a MFT associate, and now they're seeing a psychological, or they're looking for a provider, and they say, oh, in this provider directory, they have this one who is only an assistant and that one's an associate. So I think that's where there's much more confusion. And of course, as was discussed, anyone who is working under supervision must identify themselves as a supervisee. All the other requirements are still in place. So I think that's a stronger area, a much more likely area of consumer confusion. And I'm afraid we're not going to get the clarity from the other states, other than to find out that probably a psychological assistant is used in a lot of different ways. But I don't think there's going to be another category that's going to be clarifying within our state and consistent with other states. Maybe, but I think it's unlikely.
I think it would be nice to have that information.
Yeah, I think so too. I agree. That would be great. Thanks. Did you have a question?
I was just going to ask, is it fairly easy to, is there like a global directory in ASPPB for
actually,
training categories? Because if it's, hopefully it can be easily done where we ask the folks in Georgia to have a list based by state. I'm not sure if that's possible.
Mr. Foot, they do, as I haven't looked at it recently, maybe somebody else in the room has, but several years ago I looked back and they do have a listing, but I haven't looked at it in a long time, already on their website about the training categories and what's required for each.
Including their titles?
Yes.
You can actually put it on the BARC listserv and ask that question, or the board chair listserv.
I believe the booklet you were thinking of is down, and they went to a different system where it was inputted electronically. Wasn't our executive officer, Mr. Thomas, involved in that?
I actually, as you guys were speaking, I was sending a message to Mr. Thomas. Hello, Mr. Thomas. To pull this information and to reach out to the other state boards to gather what their training category is called, and if they do practice independently, if they are under supervision, so that we can get that clarification.
Great, thanks.
So where are we? Oh, sorry, Dr. Schaefer.
Dr. Schaefer again. I belong to the National Register, and if I might make a suggestion that they're a good source for the kind of information you're looking for in terms of transportability, or portability rather, of your license. So they could probably help with that too, of telling you within the states what things are called or what is needed. After about 25 years of supervising interns and postdocs and having folks move all over the country and having boards of psychology contact me because things are not the same all over, I would say that from my humble experience, trainee seems to be more generic than anything else, just in the common vernacular of board description. So the other thing I would say is California has been known to be a bellwether state for a lot of these issues. And why do we need to follow the one or two that may take umbrage, or maybe not even umbrage directly, but indirectly with it, as opposed to setting a standard that would make more sense? Just a rhetorical statement, not necessarily.
And my response to that would be, if we're going to be the bellwether, let's not do it with something that's already in use, but do it in a way that's, if we want to lead the way on something, not to create the confusion of leading the way with something that's existing already.
Absolutely, such as when my patients that know that I have a psychological assistant and are given the letter and discussed with it, a lot of them assume the person does not have doctoral training because they're assistants. Say, oh, so they have a bachelor's degree, or what is this? And I have to explain to them that the person actually, in terms of the postdocs, they already have a doctoral degree or in a doctoral program. So something else to think about in going through this. You mentioned about the stakeholder meeting, and thank you for bringing that up so much and to honor that process. There's been some other stakeholder meetings in the last couple of years and other key issues, and the experience I had in hearing people from the field is, although they gave very rigorous and passionate feedback on other issues, that a lot of that feedback wasn't honored. So the whole purpose of having stakeholder meetings is to take that information, apply it in some way, and that's understood that you're not going to do everything exactly as what's stated, but then if it's not taken into consideration in some meaningful way, then it's kind of an empty experience. The last thing I want to say is about insurance carriers, because my postdocs, I have various carriers where they can, as psychological assistants, provide service that's reimbursable. And I've done this for so long, I know who they are and how to do it. The forms that they send me for them to fill out do not say psychological assistant. They don't say any of that. They simply say, in your state, how are they registered or certified at their level? And then you put in registered psychological assistant or the term and what number is given. And I'm talking about Blue Cross, Medi-Cal, these are federal programs, so those are across states. So, for instance, to beg the question of if the vernacular is such that it would be confusing, then you would think that at a national level that there would be some form that would be using the name psychological assistant because it was so common. I think someplace like Medi-Cal would be listing it even as a checkoff, but they don't. So that information might be helpful. I know this is a challenging decision, but I hope you consider staying with what was decided and supporting what your stakeholder groups have mentioned and some of what has been shared with you elsewhere. Thank you.
There has been a suggestion from a staff member that perhaps we could retain psychological associate and just precede it with supervised psychological associate as a way of distinguishing it as a category and not creating confusion, which seems to me to be a very practical solution to the problem. So it's great that the licensing committee is going to revisit this and bring it back to us.
I just had one other thought as I was sitting there listening to this. I think in these other states, for example, in Texas, it's not so much the title that is driving this, it's that in Texas they have decided to license master's level people.
Right.
So that's the distinction. It's not that they happen to have the title of a psychological associate, but in just a few states they have made the decisions, the licensing boards themselves have made the decisions to license master's level people. And that's what makes, that's the distinction that's important. And it happens that in Texas they call it a psychological associate. I know from my my listserv of all of the executive directors and CEOs around the country, it is, Dr. Winkleman said, it's all over the map. Recently, in fact, someone from a neighboring state asked, is there any rationale for why you can only supervise 2? And she said, whatever you call them in your state, those people who have to be supervised, and there were all these responses. I said, well, here we call them psych assistants, somewhere they're called psychological extenders, another place they were called something. And it really is all over the place. And sometimes there's no particular title, it's just a supervisee or a trainee.
Right, sure.
And so I'm also willing to kind of do I think we can all pull this information together if you want to know what other states are doing, but I think you're going to find it's all over the map. But this licensure issue is a whole different ball of wax. And you as a board probably don't want to get into that right now about whether to license people. But I think that's one of the important things to keep in mind. That's why Texas is different. That's why Oregon is different.
Well, we also have, on the national level, we have the American Psychological Association making a decision to accredit master's level programs, which would suggest
To
that there's a
explore
shift.
the accreditation
Oh, they
of
haven't made
master's
that
level
formal
people.
decision
Yeah,
yet.
yeah,
But
right.
so it's a little hard to know what's going on nationally.
Exactly,
But I think
exactly.
the one thing that would be useful from doing this research is to come up with a term that would be both respectful of what the stakeholders were concerned about, but would also hopefully address my concern about engendering confusion.
Right, and I think it's good to have the conversation, and maybe this suggestion is one to consider. So again, thank you for bringing it up again.
All right, is there any more discussion on this easy issue to get through?
So if Dr. Kasuga is amenable, I'm withdrawing the
You're gonna-
motion
okay, thank you.
for this, and look forward to our discussion. And two quick thoughts. The first is that with this 3-year endeavor that Ms. Sorick just outlined, well, 3-year from this point onward, but in honesty, between Dr. Phillips and Dr. Horn and others, it's been more than, 5-6 years? So it's been a decade-long experience at this point.
It will have been by the time.
I think that's an opportunity where there's going to be some change management and communication that will have to happen regardless of where we land on this specific title, and that when we start communicating those changes for Pathways in its entirety, that it gives us an opportunity to be more flexible, to address some of these issues that we're hearing, and use our outreach and communications committee to do that, but also just the fact that we've been, just in our most recent experience with the brochure, that it was such an effective and excellent way to communicate those changes, and hats off to staff for that. So that's the first. And then the second about stakeholder engagement. I had the pleasure of serving under Dr. Kasuga when, and actually continues to chair the ad hoc task force on the EPPP 2. And, there's not an EPPP 2 in the state currently, and it's been delayed. And I think that's a reflection of what honoring that stakeholder input has been like by this board. And I want to emphasize that's happened. And so it's always good to be reminded of instances as well, specific instances as well, where that we continue to do that. So with that said, I turn it back to you, Mr.
Thank you. Okay, so that motion has been removed and, removed, I guess. Withdrawn, thank you. We are going to bring up this issue in the September licensing committee meeting, or licensure committee meeting. And we'll bring it back to the board in October for our next meeting. All right. I think that's it for the licensing committee or licensure committee, now that we've got our new name. So thank you.
Thank you very much, Dr. Horn. I am cognizant of the fact that it's been a little while since we started this meeting, and although we only have a little bit of business to take care of, I want to take a 5-minute restroom break for the benefit of anybody that needs to use the restroom. Okay, so we are going to try to finish this meeting up. We are on agenda item number 23, which is the opportunity for board members to express an interest in being president or vice president for the board in 2020. We've already talked a little bit about roles and responsibilities, and at this point I would defer to Ms. Marks to describe our process here.
Yeah, I think the board's administrative manual calls for the election of officers at the last meeting of the year. Generally, the term of office is for the beginning of the next calendar year from January 1st. This process started last year, I believe, in order to ensure full transparency and full disclosure of what people's desires would be, make sure that there was no concern about an Open Meetings Act violation if someone had suggested that they were interested in running for office. So I think what we had looked at was the possibility of board members just potentially indicating their interest or intention to seek office at the last meeting of the year. It would not preclude anybody from being nominated at the time the nominations are set or being elected would not preclude somebody from changing their mind. It was just a way potentially for people to announce their interest without necessarily feeling like they couldn't tell other board members that they were interested. Did I miss anything, Dr. Phillips? You're not required now. You could say, I don't know, and you could think about it, and would not necessarily prevent somebody from indicating their interest at the time of the elections are noticed on the next agenda.
And even less likely if someone were to express interest now and then decided not to pursue it at a later
Correct.
point in time, they wouldn't be
Right.
committed by saying it.
Right.
Just to get a general sense for board members as to who's indicating an interest. And I will start off by saying I have no interest in being president for another year. As much as I have enjoyed the position, I think 4 years has been sufficient. I'd be happy to be seated somewhere a little further out on the table. And perhaps not make so many trips to Sacramento. So with that said, is there anyone that would like to identify themselves as wanting to be a candidate for president?
I have a question.
Mm-hmm.
I want to be very explicit that I am not expressing interest in either role. But so just for my information, including at the next meeting, we'll have a period of nomination too, if we need to, right? And
Correct.
then elect, and then the term starts the next
January 1st.
Okay.
Generally, that's how the motion, I'm not sure if the board's administrative manual actually includes that, but what I have suggested in the past is that you make the term of office for a very specific term and usually beginning January 1st, so that at all times it's very clear who the officers are. I think there have been some boards that say for a term beginning at the first meeting of the beginning of the year, and because you don't necessarily know when that's going to happen, my preference is that you pick a specific date. Or not my preference, I'm sorry, my recommendation.
It does make for an easier transition if there's a definite date certain as to when the transition takes place. It gives the person also time to get prepared for that first quarterly board meeting. So.
Right, it gives a time also for transition between the last meeting and of the year and January 1st, so that the outgoing president could work with the incoming president with respect to any issues.
So would anybody would like to identify themselves as having an interest in being president of the board?
I have a question. With regards to, the sunset review process and kind of like the roles, like how does that affect people serving in those roles? Does it serve the board to have continuity in those positions during the sunset review process, or it's fine either way?
I don't know that there's an answer to that question. We'll start the sunset process with the current leadership, Mr. Fu and myself. Depending on what the results of the election is, there may be some people that continue to be involved in that process or not. That's going to really depend in part on who wants to run for the offices and also who wants to be, and what the board's preference is for who their leadership would be. I am going to mention just in general that I'm willing to serve in the position of vice president to create some continuity as it relates to going into the sunset year. But that's totally up to the board as to whether they are interested in having that done or they'd like an entirely new leadership team or whatever it would be. So I'll just put that out there now. It's not a strong preference, but it is something I'd be more than happy to do in order to allow for that transition to take place.
I just wanted to make sure I answered Ms. Cervantes' question adequately, that this is not the nomination process. The nomination process will take place at the next meeting. So someone announcing their intention does not necessarily make that a nomination. I'm not sure if that was part of your question.
Thank you.
I am going to show that I'm interested in continuing a leadership position on the board. And so yeah, it's not intention, it's interest to emphasize on that point. There's a strong distinction between the two. But I certainly do want to express my interest in being a part of the leadership team of this board. I leave that to the will of my colleagues.
So I might also, I'm not sure, but I might also like to, I'll express my interest now and, we'll see. Yeah, I just wanted to let folks know.
I might express my interest on a VP position. This is why I have the question with regards to sunset process. Seems like a lot of things, and I definitely I'm mindful of my capacity to step on such big role.
So all you would need to know is that from the point of view, just in general, from the point of view of being a vice president in a sunset year, is that you'd be one of the people testifying in front of the legislature. And you'd also be one of the two members of the committee that would be preparing all the documents in response to requests from the legislature.
Sounds interesting.
Yeah.
So I'm putting my interest.
That's one description.
And also, previously when I was nominated with Mr. Fu for the vice president, I didn't shy away from it as well. So I just wanted to share that I'm continuing to show interest, and I just wanted to say that Mr. Fu is doing a great job as well, being a VP.
Fearless or feckless, I don't know which, but one or the other. Anybody else that would like to say anything in that regard? Okay, so.
Our process, because typically we raise our hands, when when we've done this in the past. Are we going to continue that same way of voting?
I think it depends on the number of nominations. So if there are multiple people who are nominated for the same officer, I think we went around during the vote, and each board member indicated who they would vote for. I think it makes it a little more clear than if you vote one at a time for the same office. I think that gets a little murky. So I think that's how we did it last year, and I would suggest that if we have multiple nominations, that's how we would do it this year.
Last year we did vote per candidate, which I thought was an awkward process. So I think we're going to want to do an overall vote where people are expressing a preference for a particular candidate.
We did that 2 years ago.
Oh, was that 2 years ago? Okay, so I'm
Last year
sorry.
we did it.
I can't remember. All the horror stories blend together in my mind. It's rarely been a pretty process here. Anything else on item number 23? Public comment on item number 23? Any of you want to declare yourself as a candidate? No. Okay. Okay, so item number 24 is recommendations for agenda items for future board meetings. Again, remember that the board may not discuss or take action on any matter raised during this public comments section.
This is actually not an agenda item, just a clarification question for Ms. Sorick. Ms. Sorick, with regard to committee reports agendized, those committee reports are agendized when they've met in between the two board meetings. Is that correct?
Correct. Thank you very much, Mr. Fu, for pointing that out. It's two issues with that. When we space out the committee meetings like we have done over the last year, it helps facilitate a more efficient board meeting process. It is mindful of resources going into the meeting materials and the preparation, and it also kind of spreads out the committee work throughout the year. So if you do see a committee update or a report on a board meeting agenda, we will continue in 2020 to try and stagger those so that the reports out will not include all committees for each board meeting.
Thank you.
Anything else on agenda item number 24, recommendations for agenda items for future meetings? From the board or from the public? Hearing none. That concludes our agenda items, as far as I know. Would somebody like to make a motion to adjourn the meeting?
I move we adjourn the meeting.
I don't think we have to vote on this one. Adjourned.